content matter.
Yes.
No, possible.
No, kindly may be taken.
Don't accept me. Yes.
Supplemental list, item number 1.
Mention tomorrow. Yes.
No, item number.
Now we are going serially, please.
Item 1.
May I please, my lord, kindly mention the. My lord, want to mention one.
So as it appears, one has been released prematurely. The others have been granted bail, out of which 2 and 3 are available in the village and 3 has absconded. Whereabouts not known. So this matter can be heard. There is no problem.
Yes, that is told last time. We have also decided.
Yes, sir.
proceed.
This matter hearing has commenced, no?
No,
Yes,
that
sir.
is not.
Okay. Just, Mr. Das, just wait for a moment. We are taking up this other matter, then we'll come back. Just pass over. Yes, item number.
Item 2.
Item number 2.
Nobody is responsible.
Item number 2. So is available. लिखा ही जी all of it.
No.
So take down the peruse the report dated 4/8/2025 of the inspector in charge of Durga Bazaar Police Station, Cuttack UPD. It shows that the appellant Chittaranjan Mahanti is alive. But you know, beat appellant.
No. It only contains some number.
But it also Chandan Khali Acharota. Okay. Stop.
Chandan and Sharon number 10 by
Oh my God. This is my
That's the next
because this matter deals with some other way. The friend. It's from wonderful. Immediately delete from. নিজে যাই personally করবো হলো this is how G sound will become deleted. এটা খালি করে দেবো some other বলছো. Yes, next.
Item 3.
Yeah, item 2 টা কোন সমুদ্র বেঞ্চ কলা?
Yes, item number 3.
The report is there. Early. What's
Where is the report?
Yes, yes, and
Bonchijan is so. Hare Krishna. Hare Krishna. Listen, the Learned Council for the state has produced the written instruction receipt from IIC Banki Police Station dated 23/10/2025. It shows that the appellants are alive. The report is taken on record. So who is to argue this matter? Rajkishore Naik is dead. So
I will intimate Mr. Maharaj. Mohanty is not there. इसके साथ PK Maharaj is there.
no, ask him to come today
Okay.
itself.
Okay.
No question of taking adjournment. The name of Mr. Rajkishore Naik shall not be reflected in the cause list.
B Mohanty.
Huh?
B Mohanty.
B Mahanti did. Acha. Rajkishore Naik and B Mahanti shall not be reflected in the cause list henceforth. Acha. Daki diyo dakan. PK Maharaj ko dakan. It a party roila se ashram. No? Next.
Item 4.
Alive.
Report of the OIC regarding death of Balram Behra. Acha. Rajendra Saranto, Council of Relation found that
Out of the appellants,
out of Madhiji, no?
Balaram.
No, Balaram to Madhiji chala.
Forum data.
That is appellant number 3.
It is latest key.
Okay.
At the honor to
Request us.
submit the report from so. I personally visited the house from verification. It was found that Gajendra and Babaji have been charge sheeters so and so. Currently both are heading a certificate. But the other
Balaram
date agu lekha itna.
University last ଆମର ଅସୁବିଧା 2-3-21
Anjumani Road.
2-3-21 ନା ନାହିଁ ହଁ ଅଛି 11-21 ରେ it is revealed that from the report of OIC Bhadra Police that the appellant Balaram Behra has died on 29/5/12. The appellants Gajendra Behra and Babaji Behra are living in their respective homes.
ये अपडेट करना हमसे से अच्छी पाएंगे और अपूर्व होता है मतलब देखिए कर लेंगे अपडेट करो लिखो in view of the report furnished by the OIC Masda Police Station dated (25/10/2020), since the appellant number 3, Balaram Behra, has expired on 29/5/2012, and no relative of the said appellant has filed any application to continue the appeal. Accordingly, this appeal, so far as appellant number 3, Balaram Behra is concerned, is submitted. Today, the Land Council for the State Saparagalaki has produced the written instruction received from IIC Masada Police Station dated 21/10/2025. In the effect that the appellant number 1 Gajendra alias Gajia Behra and appellant number 2 Babaji alias Nirakar Behra are alive. The report is taken on record. Yes, key parivata?
Mr. Panda.
Huh?
Mr. Panda.
Mr. Panda?
I am there, Mills.
Please unmute yourself, Mr. Panda.
My lords, I am unmuted, my lords.
Yeah. Are you not able to hear us?
I can hear your lordship, but I have been muted from the other side.
No. We are able to hear you.
My lords, now I can hear your lordships.
No, have you received the paper book? The appellants are alive, so.
Yes,
we
my
want-
lords.
Okay. So, we can hear this matter either today or on Thursday. But
Today I am not ready. We can hear it next week, my lords.
We have just passed the formal orders today, and like Mr. Devasis Pandal and counsel for the appellants is present through virtual mode. And request that he is ready, but has some difficulty, and the matter may be taken off next week, and he will argue the matter. Put up this matter. Then it will come on 6th because next Tuesday is a holiday.
My lords.
This matter will be listed on 6th November 2025. You assign this matter to someone else. So get ready, huh? 6/11/2025. Okay. Now, number 5.
The 5 we have issued letter but not yet obtained. I pay so much of it.
Who is the counsel? You are the counsel.
On behalf of Arsis,
Huh?
on behalf of Arsis,
It's all right. You have received the paper book.
Yes, ma'am.
Yes. So have you got any instruction about the
No, ma'am.
well-being of the appellants?
No, man.
There are
7.
as many as 7 appellants.
Thank you.
They are belong to under one police station.
My lord, I could not get
No,
it.
I am not asking you.
Thank you. Thank you.
Yes, no. They
Binka.
one five belongs to Binka police station,
Stop in
and
1,
one
2,
belongs
3,
to
4 and
Kisan
7.
Nagar,
1, 2, 3, 4 and 7. Binka.
and the
Five-
rest two are Kisan Nagar police
Kisar
station.
Nagar.
So Kisan Nagar belongs to that district on board, and Binka is Sonpur. So have you
We have
sent
intimated
intimation?
letter but not yet received.
To get it, we are listing it on 6th of November. You get the, or have you received it? Pass on.
थोड़ा mistake है, दिल्ली से डाला हुआ है।
Rita Rita?
Yes, sir, good.
Who Rita?
Some other case.
জেরক্স করে দেবো এখন এটা এই কেস সংক্রান্তে তো এটা আমার কত নম্বর চলছে এটা 63 ক্রিমিনাল আপিল 63 of 2004 আছে তো আজের
With respect to appellant,
it came to light এটা ও দিটা কে সিআরএল এর মেসেজ দিদি it came to light that so and so
Jai Krishna Bharti. He is not from this case.
এটা হচ্ছে 113 হইতে হতো আমার আচ্ছা এটা লিখলাম
বাকিটা এই-
accused শ্রীকান্ত খন্ডায় এই কেস
Srikar.
ওটা হচ্ছে সুমতি সুমিত্রা প্রধান এই কেস
Pradhan.
arising are alive in Noapalli village or Binka police. Other accused persons.
नहीं, four dead আছে
না
লক্ষ্মণ।
না ইয়ার নম্বরটা কেতে শিখর
Sikarla A1, appellant 1.
A1 হলো
Kerala A1,
আর সুমিত্রা
Sumitra is A5.
Sumitra A5.
A5 they are alive now গলা তারপরে লিখুছি other accused persons namely একাদশিয়া বেহেরা কেতে
ଅଛି A2.
A2 অক্রূর খণ্ডায়ত
ଅକ୍ରୁର ଖଣ୍ଡାୟତ ହେଲା
Ekadashi A2,
ଅକ୍ରୁର A3.
Akura A3,
A3 লক্ষ্মণ খণ্ডায়ত
A4,
ଲକ୍ଷ୍ମଣ ହେଲା A4.
A4
সুরু
তারপরে
A6,
সুরু প্রধান
A6,
A6
অশ্বিনী
অশ্বিনী
A7.
খণ্ডায়ত
A7.
A7 they are all dead
Oh,
লিখুন the land council এটা গোটে জেরক্স করে দেবো কারণ এটা দুইটা কেস পাই দরকার 193 the land council for the state has produced the report dated 22/9/2025
alive.
of IIC Binka police station which indicates that appellant number 1, Srikara Khandayat, and appellant number 5, Sumitra Pradhan, are alive and they are residing in their village. So far as appellant number 2, Ekadasya Behera, appellant number 3, Akrura Khandayat, appellant number 4, Lakshmana Khandayat, appellant number 6, Suru Pradhan, and appellant number 7, Ashwini Khandayat, are dead. No near relatives of the aforesaid appellants, that is appellants number 2, 3, 4, 6, and 7, have filed any application to continue the appeal. Accordingly, this appeal, so far as appellants number 2, 3, 4, 6, and 7 stands abated. Baki rahila apanakara A1 and A5. So you have got the paper book.
Okay.
So you be there, we will take up this matter. এটা দুইটা কপি করে দিই, গোটে রেকর্ড রইব আর এটা রইব সে।
My lord, up to 2 weeks, sir.
No question of urgent. Hala, you to place the case, we will wait. Yes, next. Item number
Item 6.
6. Okay, ma'am, the document. Yes, the report. So number check for you. It was the CRLA 153 of 2004. ये हमारी होता जरा मार्कर पेन यूज करें। अपन उन्हें मार्कर पेन पकड़ रखूं। एक क्रिमिनल अपील और अपेलेंट नाडा ये कर दूँ। अगर बेले से ईटा केस रो पड़े उचित एक काटी तो
फिर भी दीटा के जोड़ दीजिए।
हाँ नहीं जो केस रो जो पाई जो एक्स्ट्रा गोटे कॉपी जेरोस करे नहीं क्यों हला
Santu alias Choturam,
suffering from old age staying in his house
It's
alive
alive. तोड़े आउटे केस दे दीजिए तो
सौदा हमरे तो
এইটি ଅଛି ଆଜି ଅଛି।
हाँ अजय सेटा बुझो
अजय जी सेटा को आ गोटे एटा गोटे जेरोस
तोड़ाटा
कॉपी
आउटे
सेपरेट कर
नहीं भूया तो
अछि तो एक्स्ट्रा कॉपी अछि
हाँ इतने
हाँ ठीक है एटा लिखि दियंतु CRL number 153 of 2004. The Land and Council for the state has produced the written instruction received from IAC Mohulodia Police Station dated 14/8/2025 to show that the appellant Shantu alias Choturam Mohanto is alive. The report is taken on record. The name of Mr. Smutiranjan Mahapatra shall not be reflected in the cause list henceforth. किए करिवे अपन करिवे तो पेपर बुक नहीं यही चंदी। अच्छा, Mr. B.R. Mahanti, Land Council for the appellant is present. He admits that he has not received the copy of the paper book.
will also receive.
So also the Land Council for the state, let the copies of the paper book be handed over to the Land Council for the appellants, so also the Land Council for the state during course of the day. As prayed for by the Land Council for both the side, lays this matter on 6th of November 2025. So take immediately, a sign will be made. Next,
Item 7.
Even report is there.
you do.
Take a date.
Oh, see that.
There
সেটা তো
second test.
ଆଜିରେ ଅଛନ୍ତି 4 ଜଣ। କ୍ରିମିନାଲ ଅପିଲ 170 ରିପୋର୍ଟ କାହିଁ
ସେ ଯୋଉ ଆଗଟା ଦେଖା ଦେ ସେକେଣ୍ଡ ପେଜ ରେ
Second
ଟ୍ୟାଗ
page,
ହେଇଯାଇଥିଲା ବୁଝିଲେ
second is
ସେ ଟ୍ୟାଗ ହେଇଯାଇଥିଲା ବୁଝିଲେ
second.
ସତୁରି ନମ୍ବର ଲେଖା ହେଇଛି
What is it?
ଶହେ ସତୁରି
ଏଇଟା କି ହଁ ତାହେଲେ ଏଇଟାକୁ
ସେଟା ଅଲଗା ଟା
ହଁ ଏଇଟା ବାହାର କରିଦିଅ
That is always the
ଏଇଟା ସତ ବାପି ନିଅନ୍ତୁ କିଏ ବଞ୍ଚିଛି କିଏ ମଲେ କୁହ ବାବୁଲା
କରନ ଦାସ
A appellant one.
ଏଇଟା ହେଲା ଆପେଲେଣ୍ଟ ୱାନ୍ ବଞ୍ଚିଛି ଲାଇଭଲିହୁଡ ଆଚ୍ଛା
Karnadas appellant two is like alive. One, two.
ଟୁ
Rama
ଟାଇପ
Biswal alive. एक दुई तीन alive.
ଆଜ୍ଞା
चारटा मतलब
ନାଇଁ ଦୁଇଟା ଡେଡ୍
ସତ୍ୟବାଦୀ ଅଛି
କରନ ଦାସ ଡେଡ୍ ଏକ୍ସପାୟାର୍ଡ
ମାନେ କର୍ଣ୍ଣ ଦାସଟା
ହଁ କର୍ଣ୍ଣ ଦାସ
କର୍ଣ୍ଣଦାସ ଏକ୍ସପାୟାର୍ଡ
ଭେରିଫାଇଡ୍ କର୍ଣ୍ଣ ଦାସ
expired
ଏକ୍ସପାୟାର୍ଡ
about 4 months.
4 months.
ଆଚ୍ଛା
କର୍ଣ୍ଣ ଦାସ expired.
ଆଚ୍ଛା
ଅଦର ଥ୍ରୀ ଆଲାଇଭ୍
ବାକି ତିନି ଜଣ
working and the location acha listen here is the written report dated 8/10/2025 of IAC Khalikot Police Station produced by the Land Council for the state, which shows that appellant number 2 Karnadas is dead. However, the other appellants, that is appellant number 1 Babula Das, appellant number 3 Rama Biswa, and appellant number 4 Satyavadi alias Satyadas are alive. The report is taken on record. Since none of the near relatives of appellant number 2 has filed any application to continue the appeal, therefore this appeal, so far as appellant number 2 Karnadas is concerned, stands abated. बाकी एटा हला अपन करो yes with the council here you are there, you have received the paper book.
Yes, sir.
The land council for the what is your group name?
use fund
Huh?
use fund
Please give it in writing. So you are appearing on behalf of Mr. Pahi.
yes sir.
Mr. Pahi is present and submits that he has received the paper. You just be there, may take up this matter. Okay. Next, item number 8.
Very difficult.
Yun.
sole appellant alive.
Sole appellant alive.
Brahmananda Burgi.
The land council for the state has produced the written report dated 10/10/2025 of DSP in charge of Sarangod Police Station, which shows that the appellant Brahmananda Burgi is alive. The report is taken on record. In the council, Sarat Kumar Das is fine, BB Pradhan. Janichandi. Janadi.
From CDA, Sarathanda, he is no more. I'm verified.
Now engage कर दो panel Sarat Kumar Das, Siddharth Swain और बिहारी प्रधान
हाँ सही बोलते हैं हमारा CDA
हाँ
CDA सरता की
Johnny way
I will intimate the Mr. Swain.
either Sarat Das जाना तो
Sarath
Siddharth
Das का नाम दिया
वो अच्छा है sorry वो Sarat Das मैंने जी
CDA stand comment
गवर्नमेंट एडवोकेट अच्छा
Both this, yeah. I'm not sure, but it is swine.
Siddharth Swain?
ତାଙ୍କରି ପାଖରେ ସ୍ୱାଇଁ ଥିଲେ।
ନାଇଁ ସିଏ
ଜାତ
ଅଛନ୍ତି।
ଅଛି, ହଁ sir।
ଆଉ ବିନୋଦ ବିହାରୀ ପ୍ରଧାନ?
ତାଙ୍କୁ ମୁଁ ଜାଣିନି, ସ୍ୱାଇଁ କି ଆଇଲି ଇଣ୍ଟରଭ୍ୟୁ।
ସ୍ୱାଇଁ ଜଣେଇଦେବେ।
ଆଜ୍ଞା।
ସିଦ୍ଧାର୍ଥ ସ୍ୱାଇଁ।
Yes, sir.
ତ ଜଣେଇ ଦିଅନ୍ତୁ ତାଙ୍କୁ।
ଆଜ୍ଞା।
The Land Council for the state submits that Sarath Kumar Das is no more and will intimate Mr. Siddharth Swain, advocate, about the listing of the case. Put of this matter on 6th of November 2025. The name of Mr. Sarath Kumar Das shall not be reflected in the cause list. Yes, next.
Item 9.
Sole appellant, Jaya Krishna Bharati, alive. Mr. Panda is here.
এটা কোঠিকা ম্যাটারটা কেন
Jim,
এটা যদি কেউঝর ହେଇଥିବ then I may not appear because maybe given may have been absent.
Mr. Panda, this, it is phone, it is?
Bin facts.
इतने कौन अपने?
Then I'll obtain paper books and appear.
Just,
Just second. This is Jaya Krishna.
oh, click on the CRLA number 193 of 2004. This is item number 9. Mr. Devasis Panda, Land Council for the appellant is present. The Land Council for the state has received written instruction dated 22/9/2025 of IIC Binka Police Station, Suvarnapur, to show that the appellant Jaya Krishna Bharati is alive. The report is taken on record. Mr. Panda, have you received the paper book?
No, I don't have the paper book. I'll obtain the paper book. Your lordship will.
Please ask someone to collect it today itself.
I'll do it.
Mr. Panda, Land Council submits that he will collect the paper book during course of the day. You have received the paper book? And the matter may be taken up next week for hearing. Place this matter on 6th November 2025. Yes, next.
Item 10.
Item 10, madam, press report is required. Year number 1119, because they have something.
The it is sole appellant achi
My lord,
209 of 2025.
my lord.
At 209 of 2004. acha.
They have submitted a report, GR case number 113 by citizen Baripada, and CS case number 7/3, that is wrong. That is not correct.
GR case number 119 pura
1119,
1119.
1119.
ठीक तो अछि जजमेंट तले लिखा है ना
And
arising of
1119.
Oh,
So it could be 1119.
1119.
भाई इतने केस को
एते थियो.
बारिपदा रे ठीक है GR केस 2003 ने
Now, what is the name of the person? No, your information which you have received.
Information, my lord.
Bajinath Marandi.
Bajinath Maran.
Yes.
अछि तो ना तो ठीक अछि ना
ना ठीक है.
PS case number केते दिखन?
PS case number 85.
PS case number 85 ये बार को ट्रायल कोर्ट रिकॉर्ड ना एक बार तो 85 ठीक है
ठीक है, this information.
ठीक है दियो न कार्ड
Yeah, man. Is
One-
alive?
अलग तो look on the Dr. Sujata Das, Land Council for the appellant is present. Land Council for the state has produced the written instruction dated 16/8/2025 of DSP in charge of Bangiri Police Station, which indicates that the petitioner, either the appellant is
Bajinath.
uh,
Bajinath.
what is it?
Bajinath Marandi.
लिखा है जी Upland Bajina, so on verification of the no case was found. Further verification, it came to light, so has been raised.
Inform something.
Voicing our case case number 7/3.
ବଞ୍ଚିଛି କି ନାହିଁ କରିବା କଣ
Sir, that
ଏଇଠି
is
କଣ
to be verified because I
ଆପଣ
was
ରିପୋର୍ଟ
informed by my local advocate that he has died, but not confirmed.
So it is not.
ଆପଣ ଏଗୁଡାକ ଆମେ କଣ ମାଗୁଛୁ ତା ନାଁରେ କ୍ରିମିନାଲ ଆଣ୍ଟିସିଡେଣ୍ଟ ମାଗିଛୁ ନା କଣ ଇଏ ତ ସବୁ ଠିକ ଅଛି 7/20 ବାଙ୍ଗିରି ଏ ଯୋଉ କଣ ବୈସିଙ୍ଗା ପୋଲିସ ଷ୍ଟେସନ ଦେଖି
Giripus.
Bangiri Pussy is all right.
No, it is Bangiri Pusi, but it is mentioned as Boisinga. I would have found. This is not the Mr. Pradhan. This is not the correct information as we find because the name of the criminal appeal number is right. That is 209 of 2004 and name of the appellant is also right, Bajinath Marandi. But as we find that from the judgment that this case relates to GR case number 119 of 2003 from SDGM Baripada. But the GR case number which it has been mentioned here is something different. It was 111 of 2003.
111 of
ତାପରେ ଆପଣ ଏଠି ଲେଖିଛନ୍ତି ବୈସିଙ୍ଗା ପିଏସ୍ ଏଟା ବୈସିଙ୍ଗା ପିଏସ୍ ନୁହେଁ ଏଟା ହଉଛି
Bangiri Pussy PS case number
Bangiri
85. And this is also some other name. 7 of 2000.
7 of 2000. This is not. It's not correct. ଲେଖନ୍ତୁ କଣ ଲେଖିଲେ Nine, which though indicates that the instruction relates to the present appeal, that is CRLA number 209 of 2004 in respect of the appellant Bajinath Marandi. But on verification, it appears that
Instructions are in respect.
the instruction relates to
Bangiri Pussy PS.
Bangiri
Boisinga PS case.
Boisinga PS case number 7 of 2003. And the GR case number has been mentioned to be 111 of 2003 of SDGM Baripada, though the present case relates to
Bangiri Pussy PS case.
Bangiri GR case number 119 of 2003 of in the court of SDGM Baripada, which arises out of Bangiri Pussy PS case number 85 dated 23/11/2002. Stop.
FR it has been mentioned 1119.
Huh?
FR it has been mentioned 1119.
Kooti?
ବୁଝିଲେ କଣ ଏ ପ୍ରାୟ କହୁଛି ନା FIR 111 କଣ
1119.
କାଇଁ FIR କୋଉଟା that GR number is something else.
କଣ କୋଉଟା କହିଲ
So 1119 ବୋଲି we are not on that.
এটা ହଉଛି ବାଙ୍ଗିରି ପଶି PS case number 85 ହେଲା ଆଉ GR case ଟା judgment ରେ ଲେଖା ହେଇଛି ଦେଖି judgment out ବାହାର କର GR case number 119 of 2003 ଏଟା ଠିକ ଅଛି
119 of 2000.
ଏଇଟା କଣ 2 ଲେଖା ହେଇଯାଇଛି
2002. This is 3.
It cannot be GR case of 2002 because the case, the FIR has been lost. Yes,
23/11 দুই হ্যাঁ
তো এটা
23/11 দুই
ঠিক হয়েছে।
ঠিক ঠিক মানে
কোন লিখলা হচ্ছে পড়ন মোড় স্লো করুন ফাস্ট পড়ুন which indicates though the instruction relates to the present appeal, that is CRLA number 209 of 2004, and the name of the appellant has been correctly mentioned as Bajinath Marandi, hala? But the GR case number has been mentioned to be 111 of 2003 of SDGM Baripada, and PS case is Boishinga PS case number 7 of 2003. Hala? The present appeal arises out of the sessions trial case number 3/114 of 2003, which arises out of GR case number 119 of 2003 from the Court of Law and SDGM Baripada, and the PS, and it relates to Bangiriposi PS case number 85 dated 23/11/2002. The Land Council for the state seeks some more time to obtain correct instruction about the well-being of the appellant Bajinath Marandi. List this matter on 6th of November 2025. Pre-copy of the order be handed over to the Land Council for the state. आदि आपनकर PS केस नंबर ईयर भूल अछि और GR केस नंबर ईयर भी भूल अछि। आपन जो इंस्ट्रक्शन ता आनी चंदी एटा होची 2003 मसिया रो ये केस ता होची 2002 रो FIR भी 2002 रो और GR भी 2002 रो आपन ने भूल ले आनी चंदी 2003 नो बाकी से क्रिमिनल अपील नंबर ठीक अछि appellant ना ठीक अछि है ना
केस नंबर
हां
यस केस
Dr. Sujata Das is present कर देगा हाँ 6 तारीख है 6/11/2025. Yes.
Item 11.
yes
His earning is liable.
yes पड़ा
Appellant और नाटक को ये करेगा मारी भी देगा लेकिन the you are for the appellant. You are Mr. Naim. Sheikh Abdul Naim, Land Council for the appellant is present. Stop. The Land Council for the state has produced the written instruction dated 19/8/2025 of Deputy Superintendent of Police in charge, Talsara Police Station, which shows that the appellant, Jacquias Bada, is alive. The report is taken on record. You have received the paper book. The Land Council for the, you have received the paper book. The Land Council for the appellant submits that he has not received the paper book. Let a copy of the paper book be handed over to the Land Council for the appellant. Matter be listed on 6th of November 2025. Yeah. Receive कर नहीं जानता. Next.
Item 12.
12, I am there, paper book is also with me.
What about the well-being? CRLA 233 Shankar Naik is staying alive. Look, Mr. Devasis Pandal, Land Counsel for the appellant, is present, virtual mode. Land Counsel for the state has produced the written instruction dated 21/8/2025 of IIC Sadar Police Station, Puri, which shows that the appellant is alive. The written report is taken on record. Mr. Panda submits that he has received the paper book and seeks for an adjournment, leaves this matter on 6th of November 2025. Yes, next.
Item 13.
Yes. How many appellants? A bit with each. Appellant number 1, Bhaskar Behra.
These are Salat Behra. 19/8/5
बाकी आरोटा शरद बेरा बेल आउट स्टेइंग लिखो the Land Council for the state has produced the written instruction dated 17/8/2025 of IIC Balimi Police Station, Tenkana, to show that the appellant number 2, Sarat Behra, is alive. The written report is taken on record. Mr. B.R. Mahanti, Land Counsel for the appellant, is present. You have received the paper book. Let a copy of the paper. I submit that he has not received the copy of the paper book. Let a copy of the paper book be handed over to the Land Counsel for the appellant. The name of Mr. Smruti Ranjan. Upon name, so also the Land Counsel for the state. The name of Mr. Smruti Ranjan Mahapatra shall not be reflected in the cause list henceforth. Matter will be listed on 6/11/2025. Yes.
Item 14.
On behalf of SK Divedi. They are alive.
Yes, the report. There are 3 appellants.
Bhagavan Kasturi and Raghu.
Bhagavan Kasturi
Sethi, Ravindra Singh.
organization. Land Council for the state has produced the report dated 21/8/2025 of IIC Gangapur Police Station, which shows that all the 3 appellants are alive. The report is taken on record. You are appearing for the. What is your good name?
SK Behra. On behalf of SK Divedi.
Acha. So, so and so on behalf of Mr. SK Divedi is present, and you have premature release.
Ravindra.
No, the report dated premature release of Bhagavan.
Oh, thank you.
देखिए आप appellant नाम भगवान. हाँ, item number 1. अच्छा, the there लिखी जाऊँ the report has been received, which is that flag aim of the Deputy Inspector General of Prisons Headquarters. It shows that the appellant number 1 has been released prematurely. You know, Satikal like this on. So and so.
ରବୀନ୍ଦ୍ର ସେଠି ପୁଣି
সেটা কাটিদেবা সেটা ଏଇଟାକୁ dispose of କରିଦେବା ଯଦି ସେଇ ରବୀନ୍ଦ୍ର ହେଇଥିବ।
ହେଲା ବାପା ନା ଭଗବାନ ସେଠି।
ଏଇଟା ଲେଖିଲେ କି ସେ ଆପଣ ପେପର ବୁକ୍ ଅଛି ତ ମିଷ୍ଟର ଦ୍ୱିବେଦୀଙ୍କ ନାଁ ଲେଖିଦିଅ। Submit that he has received the paper book. Mr. Dwivedi, the second case you have filed?
Yes, ma'am.
No, Rabindra Sethi.
Oh, I have had.
The first one you have filed. Mane,
Second one
you are
also.
appearing in item number CRLA number 257.
And the second one also I have had.
but he is a different man. He's different.
Oh, Rabindra Sethi, ইয়ার নাম হচ্ছে ভগবান সেঠি। সেই সেকেন্ডটা
এটা হচ্ছে নীলু এলিয়াস।
আচ্ছা ইয়ার কোন হলা?
নাল্লু এলিয়াস লাল।
अन्ना दी নিয়াস তাদের তো লেখা হয়নি, তাদের 3 জনଙ୍କର নাম লেখা ହେଇଛି। ভগবান his wife and রবি সেঠি, but ଏ রবি সেঠি ଅଲଗା ଲୋକ।
son of ନାଲୁ ଏଲିଆସ ଲାଲମୋହନ ସେଠି।
ଲେଖନ୍ତୁ CRLA number ତାର ଯୋଉ connected appeal ଅଛି CRLA number 235 of 2004, the Mr. S.K. Dwivedi, Land Counsel for the appellant is present. Land Counsel for the state seeks some more time to obtain the well-being report of the appellant put up this matter on 6th November 2025. କାହା ନାଁ ସବୁ କଟିବ କହିଦେଲେ କଟିଦେବା। ପ୍ରଥମଟାରେ କାହା ନାଁ କଟିବ? ବାସୁଦେବ ମିଶ୍ର and his associates। ଆଉ କିଛି କଟିବ? GP ଦତ୍ତ and associates ସେଟା କଟିବ। ମାନେ ଆପଣ କାହା ନାଁ ରହିବ କୁହନ୍ତୁ? SK ଦ୍ୱିବେଦୀଙ୍କ ନାଁ ରହିବ। ଆଉ
RK Mohant. RK Mohant ଆଉ ଏନ।
RK ମହାନ୍ତ ଆଉ ଏନ ହୋତା। ଆଉ ବାକି ସବୁ କଟିଯିବ। ଫାର୍ଷ୍ଟ ଲେଖନ୍ତୁ in the first item ଲେଖନ୍ତୁ except the name of Mr. SK Dwivedi, RK Mohanto and N Hota, the name of other land and council shall not be reflected in the cause list henceforth. Second टा कुहନ୍ତୁ?
Second ଟା ଖାଲି ମୋ SK Dwivedi।
अच्छा, second रे except the name of Mr. SK Dwivedi, the other names shall not be reflected in the cause list henceforth. है ना? Next item.
Item 15.
There are two appellants.
There are two appellants. I have received the
Niranjan Perai
Perai.
ଆଉ ଗୋଟେ ହଉଛି ଦେବେନ୍ଦ୍ର ପେରାଇ।
both the appellant on bail and also alive.
ये जो ଇଏଟା ଇରେ ଯୋଉ ମାର୍କରରେ ମାରିଦେବେ କ୍ରିମିନାଲ ଆପିଲ ନମ୍ବର ଆଉ ଆପେଲାଣ୍ଟର ନାଁ ଏତିକି ମାରି ଦେଇଦିଅ। ଲେଖନ୍ତୁ the land and count, this is criminal appeal number 260 of 2004. The land and council for the state has produced the written instruction dated 38/2005 of IIC Town Police Station Keonjhar, which shows that the appellants Devendra Perei and Niranjan Perei are alive. The report is taken on record. The you are an associate of Mr. DP Dhar. You have received the paper book.
Yes.
Na diyandu, so and so. Appearing on behalf, you have got the power in this case?
No.
Achha. Appearing for Mr. DP Dhar and senior advocate submits that he has received the paper book.
The state has not received the paper book.
The land council for the state submits that the paper book is, he has not received the copy of the paper book. Let a paper book be supplied to the land council for the state. State food they deve, hai na? Put up this matter on 6th of November 2025. है ना? Hold on.
Item 16.
Yes, item number 16.
I have received the instruction, my lord. The appellant involved in another case.
No, see how involved amor bonchiji ki nahi darkar.
Yes, sir. Now in jail, sir.
He is released from this case, but he is in detention in another.
On 18/11/2000, accused is released on bail by the order of this court. Wala. He is in jail custody. What was it? The periodic report dated 8/5/2025 of IIC Lohunipada Police Station, Raurkela, which shows that the appellant is so that though the appellant was released on bail.
Say 8/5. This report.
अच्छा এটা তো বললা ফোন করতাম যে appellant বললো custodian
One of the first.
2005 ରୁ 2013 ତା ପୂର୍ବଟା ହେଇଥିଲା 2005 ପର୍ଯ୍ୟନ୍ତ ଏଟାକୁ ଏକ୍ସଟେନସନ କରାଇଲେ 2013 so it is also the appellant is in judicial custody but in connection with another case है ना so the report is taken on record. You are there?
No,
You have received the paperwork?
no. State has not received.
Give your name, so and submit that he has received the paperwork. The name of Mr. S.R. Mahapatra shall not be reflected in the first list henceforth. Land counsel for the state submit that he has not received the paperwork. Let a copy of the paperwork be supplied to the land counsel for the state. Matter will be listed on 6/11/2025. Next.
Item 17.
I have received the instruction, my lord.
Yeah.
The appellant is alive.
Sole appellant.
Sole appellant.
CORAM Malik. Alive. Look on. CRL number 6 of 2008. The Land Council for the state has produced the written instruction received from DSP Soro Police Station dated 2/5/2025 that the appellant is alive. The
Paperwork
opportunity Land Council for the appellant is present. Upon paperwork received present.
Received.
Upon be received present. Both the Land Council for the appellants, also the Land Council for the state submit that they have received the paperwork. Matter be listed on, the report is taken on record, matter be listed on 6/11/2025 for hearing. Yes, next.
Item 18.
Item 18. I received the instruction.
Council Land Council has produced the postal receipt dated council memo to show that the order dated sponsor has been communicated to the contemner state.
20 application disposed of in accordance with law and
Yes. The Land Council for the state has produced written instruction dated 28/10/2025 of Spacer Relay and RRO from Lower
Indravati.
Irrigation Project Kharia to show that the order has been complied with. The report is taken on the content proceeding is closed.
Item 19.
After the receipt, my lord. 20 application disposed of and the estimated amount of 30,01,873. The decretal due has been prepared and submitted to government. and it is awaited for a sanction.
Let us make the check for the dispose of further. Yes, next. Copy दीजिए तो हाँ थोड़ा भी ये जी copy दीजिए. Next.
Item 20.
Receive instruction, my lord. The notice has also been issued to the petitioner for receiving the decreed amount he had not received.
Ask your client to go and
Yes, sir.
receive the money.
Yes, sir.
Hala, receive also compliance disposed of. Next.
21 that after launch next week the
21
next week.
আমি তো বসছু না ইয়ে দিন গুরুবার দিন বসছু.
Well.
Let it come. If you are ready that, if you are sure that it will be
Yes, yes.
come to me to itself. Acha, as prayed for by the Land Council for the state, list this matter on.
If my lord after launch I will receive the instruction, I will mention.
আচ্ছা ঠিক আছে এটা কু
তাহলে 500 বার লিখতে হবে?
500 বার এটা থাও না ওকে থাও. Next.
22. Item 22.
52 millet with some more time to comply.
ଆପଣ
ସବୁ launch ପରେ ସବୁଥିରେ item up to 25 I have talked launch ପରେ
আচ্ছা ହଉ ଠିକ ଅଛି 21 ରୁ 25 ଲଞ୍ଚ ପରେ ଡକା ହବ.
my lord.
ହେଲା ମିଷ୍ଟର ବେରା you remain present.
Yes, sir.
Yes.
Item 26.
No, sir.
Sir, in the case flood with some more time.
ଆଜି ଆସିବ କି?
Yes, sir. The mines department capital.
Next week run. The Land Council for the state seeks some more time to obtain instruction regarding the compliance of the order. Put up this matter dated on 6th of November 2025. Mr. Subhankar Rao, Land Council for the petitioner is present. ये जो launch पर आगे गुड़ा रखी हो ना से contempt petition गुड़ा. Yes.
Item 27.
Your Honor, I am advocate for this advocate in this case, and in that meantime, for these petitioners, since these are the whistleblowers in the NHRC case, I have filed a public interest litigation case, PIL case.
Notification you want?
Yeah, I want modification. I am just telling that I have filed in that meantime a PIL also.
You filed that.
So I pray for hearing of both these cases simultaneously.
Yes, we are disposing of. I for so for modification of the order dated 17/4/2025. After going through the our taken in this one, so we are not inclined to modify the order, and the accordingly the.
I want to modify that order.
You want to? We are not interested to. We are not inclined to modify. Yes. Next.
Item 28.
Item 28.
File is so good. The lordship connected matter posted to 24th regarding to further development in matter. Seek it took time to take further instruction and regarding complaints of my lord father.
No. There are connected matter posting each na कौन? 24/11. कितना number था? Number पे दो.
CONT is now 879/2020.
Pass on that order. Let us see. You have filed case.
Yes, it's on.
चिल्लीकुरी भेंकाना. अच्छा. The Mr. Mahanti, Land Council appearing for the contempt submits that contempt application number, petition number 879 of 2025 is connected to this contempt petition, which is fixed to 27/11/2025. And this matter may be taken up on that day with the said contempt petition. And In the meantime, he will obtain necessary instruction in the matter. Put up this matter on 27/11/2025 with contempt petition numbers 879 of 2025. এটা পুরো clear. Yes. या जरूर ये जो हियरिंग जो किसी पाठ रही लगी ताज पड़ा
230
आओ किसी
नहीं जो बेस आएगा तो जो शेयर है 238
उठा
शेयर है आइटम 35 का बेस रायगुरु
35 ପାଠାଡ ହେଇଥିଲା
ପାଠାଡ ହେଇଥିଲା
କିନ୍ତୁ ରାୟଗୁରୁ ରିକ୍ୱେଷ୍ଟ କରିଥିଲେ ଯେ ଆଭେଲେବୁଲ ରହିବେ ନା
हाँ we have we propose to reserve this today and provided that you took time to file the where is Mr. Rayaguru?
ସେ ରିକ୍ୱେଷ୍ଟ କଲେ ଆଜି ଆଭେଲେବୁଲ ରହିପାରିବେନି ଗୁରୁବାରକୁ
अच्छा गुरुवार दिन ठीक चले तो रोहित so we'll take up this item number 1 then huh? Yes Mr. Das. In your case, appellant number 1, Rupa Jerai has been released prematurely. The other 3 are alive, out of which 2 are staying in the village. 1 whereabouts is not known. That is appellant number 3, perhaps. Yeah.
So we want to compare it to
2, 3 and 4 out. What absconding করছে না
তিনজন করে আমাকে তো রূপা দেবে ছাড়ি
হ্যাঁ রূপাচারী রকম সেটা বলা হয় 2, 3 and 4 they are on bail. তারপরে information available ହେଲା କିଏ ଅଛନ୍ତି କିଏ ଗୋଟେ ଫେରାରି डेट होची हाँ 2, 4 are village अच्छा 2, 4 available in village the order dated 21/8/2025 और एक भी लास्ट नॉलेज होती है P02-201-34 Mr. Das, please come to the city mic or city please come to the FIR. Yes, that is at page now 35. Your associate is not there with you, Mr. Das?
No. Associates are there in various courts.
Achha, all right.
I have asked them to go there.
No, ठीक है। मुझे लिए जो FIR करी ऐसे मैंने पढ़ी था तो सीख पाए।
वो FIR में पढ़ दी।
अच्छा। अच्छा।
कुमारी सस्मिता
जेराई की कितने नंबर सकी? 1 नंबर।
PW1
हाँ, पढ़ो।
In fact, there is no eyewitness to the occurrence.
Just let us go through the
Yes, yes.
ହଁ
ପିତା ସତ୍ୟଂଶ ବାଦାମ ଏଇକି
ଆଜିରେ ଡିସିଜ ନାଁଟା କଣ?
Upinath Jorai.
Retani alias Raimoni.
ରାଇମତି ଜେରାଇ
Raimati Jorai.
Raimati.
ବେଶୀ ଦେଲା ରାଇମତି ମତି ନା ମଣି ଆଲିଆଜ ରାଇମଣି ଆଲିଆଜ ରାଇମତି
ରାଇମତି ଜେରାଇ
Page 35. Right.
ଆଚ୍ଛା ଏଥର ପଢନ୍ତୁ ହବ
ଏଇକି ମୋର ବାପା ଗୋପୀନାଥ ଜରାଇ ଆଜି ପ୍ରାୟ 5 ରୁ 6 ବର୍ଷ ହେବ ମରିଯାଇଛି। ମୋର ମା ରାଇମତି ଜରାଇ
ଏଇଗୁଡାକ ହଉଛି ଡିସିଜ୍ଡ।
ରାଇମତି ଜରାଇଙ୍କ
ସହିତ ମୁଁ ମୋର ସାନ ଭାଇ ରୂପେନ୍ଦ୍ର ଜରାଇ ଓ ପିଉସୀ ସୀତା ଜରାଇଙ୍କ ସହିତ ଏକାଠି ରହୁଅଛୁ। ଗତ 25/9/19 ଆମ୍ଭ କାଠଭାରିଆ ଗ୍ରାମର ଭରତ ଜରାଇ A2 ହୋଇଥିବା
ଭରତ ଜେରାଇ ହେଲା
A2
ଆଚ୍ଛା A2
ହୋଇଥିବା 1 ମାସର ଝିଅ ଛୁଆକୁ ଜର ହୋଇ ମରିଯାଇଥିଲା। ସେଇ ମରିଯିବାରୁ ତାର ବାପା ଭରତ ଜରାଇ ଏବଂ ଗ୍ରାମର ରୂପା ଜରାଇ A1
A2 ଆଉ A1
କନ୍ଦା ଜରାଇ A3
ଅନ୍ଦାଜରେ A3
ଦଶେ ଜରାଇ A4
ହଁ
ତାର ମରିଯାଇଥିବା ଝିଅକୁ ପୋଡୁଥିବା ସମୟରେ
ପୁରୁଣା ପୋତୁଥିବା ସମୟରେ
Pututhua.
ଏମାନେ ମିଶି ମୋର ମାକୁ ଡାହାଣୀ କହି ତାର ଝିଅକୁ ମୋର ମା ମାରିଦେଇ ବୋଲି କହିବାରୁ ମୋର ମାଙ୍କର ସେମାନଙ୍କ ସହିତ ପାଟିତୁଣ୍ଡ ହେଲା।
ଓକେ
ଏଥିରେ ଭରତ ଜରାଇ A2 ଏବଂ ରୂପା ଜରାଇ A1 ମୋର ମାକୁ ବିଦା ଚାପୁଡା ମାରିଲେ। ମୁଁ ମୋର ପିଉସୀ ସୀତା ଓ ଗ୍ରାମର ଜଟିଆ ଜରାଇ
ଅଛନ୍ତି କି ଏକ୍ସାମିନ ହେଇଛନ୍ତି କି? ମୁଁ ମୋର ପିସି ସୀତା ଜଟିଆ ଏକ୍ସାମିନ ହେଇଛନ୍ତି କି ଦେଖିଲେ?
ସୀତା A7
A7 ନୁହଁ PW7
PW7
ହଁ ଆଉ ଗ୍ରାମର ଆଉ ଗୋଟେ କିଏ ଜଟିଆ
ଆଜ୍ଞା
ଜଟିଆ ଜରେଇ ହେଇଛି
ଜଟିଆ PW11
PW11 ଆଚ୍ଛା ହଁ ଆସି PW7 ଆଉ PW11
ଏମାନେ ଆସି ଗଣ୍ଡଗୋଳ ଶାନ୍ତ କରାଇ ଦେଇଥିଲେ।
ଆଚ୍ଛା
ପରେ ମୋ ମା ଓ ଆମ୍ଭେ ଆମ୍ଭ ଘରକୁ ପଳାଇ ଆସି ଖାଇ ପିଇ ଦେଇ ସବୁଦିନେ ରୂପା ଜରାଇ ଘର ପାଖରେ ଥିବା ଗୋଟେ ଘରେ ଶୋଇଲେ।
ସବୁଦିନ ପରି ହେଇଥିବ
ସେଟା ଲିଭି ଯାଇଛି ସେ ସାଇଡ
ପାଣି ପଡିକି ଲିଭି ଯାଇଛି।
ସମସ୍ତେ ଆମର ଆଉ ଗୋଟେ ଘର ପ୍ରାୟ 300 ଗଜ ଦୂର ଥିବା ଘରେ ରାତି ପାଇବାରୁ ମୁଁ ଏବଂ ମୋର ପିଉସୀ ମିଶି ମା ରହୁଥିବା ଘର ଆଡେ ଯାଇ ଦେଖିଲୁ। ମୋର ମା ଶୋଇବା ଘର ଖୋଲା ଅଛି। ଆମ୍ଭେ ତାକୁ ଖୋଜାଖୋଜି କଲୁ କିନ୍ତୁ କୌଣସି ସନ୍ଧାନ ପାଇଲୁ ନାହିଁ। ଏହା ଦେଖି ଗ୍ରାମର ପୋଷ୍ଟମାଷ୍ଟର ପୂର୍ଣ୍ଣ
ନାୟକଙ୍କ ଘର ଆଡକୁ ଯାଇ ପଚାରିଲୁ।
ଘର ଆଡକୁ ଯାଇ ପଚାରିଲୁ ସେ ଆସିଛି କି ବୋଲି। ସେ ମନା କଲୁ। ଆମ୍ଭେ ଘରକୁ ପଳେଇ ଆସିଲୁ। ଏହା ପରେ ଗୋପାଳ ଜରାଇ PW5
ହଁ
ମୋର ଭିଣୋଇ ଓ ଗ୍ରାମର ପୁନା
ଚୌକିଦାର ଗ୍ରାମର
ଚୌକିଦାର ଏବଂ
ପୁନା ସୁଆଂଶୁ
ସୁଦର୍ଶନ ଗାଗରାଇ PW6
ଆଉ ସେ ପୁନା ଏକ୍ସାମିନ ହେଇନି ଆଦି ଲୋକମାନଙ୍କୁ
ଡାକି ଆଣିଲେ।
ହଁ
ପାଖରେ ସମସ୍ତ ଘଟଣା କହି ସେମାନଙ୍କୁ ଧରି ଗ୍ରାମର ପୁରୁଣା ସରପଞ୍ଚ ନାଁଟା ଏଇଟା କଟିଯାଇଛି ଜରାଇଙ୍କର ଘର ପାଖକୁ ଯାଇ ମୋର ମା କଥା କହିଲୁ। ଆମ୍ଭେ ତାଙ୍କୁ ରୂପା ଜରାଇ ଓ ଭରତ ଜରାଇ ଘର ପାଖକୁ ଯାଇ କଲାଲ ଜରାଇ ସେମାନଙ୍କୁ ମୋର ତାପରେ ଦୋଷ ନେଇକି ସବୁ କଟିଯାଇଛି। ରୂପା ଜରାଇ କହିଲା କାଲି ତାପରେ ସବୁ କଟିଯାଇଛି। ନଦୀ ଆଡେ ଯାଇ ବହୁତ ଖୋଜାଖୋଜି କଲୁ କିନ୍ତୁ ମୋର ମାର କୌଣସି ସନ୍ଧାନ ନ ପାଇ ଥାନାକୁ ଗ୍ରାମର ଶୁକ୍ଲାଲ ଜରାଇ PW2
PW2
ହଁ ମୋର ପିଉସୀ ସୀତା ଜରେ
Hmm.
ସୀତା ହେଲା PW7
Hmm.
ବିନୟ ଶୁକ୍ଲାଲ ହେମ୍ବ୍ରମ PW4
Hmm.
ଗ୍ରାମର କୁନା ମହାକୁଡ
ହେଇନି ପରା କହୁଛନ୍ତି ଏକ୍ସାମିନ ହେଇନି କୁନା
ନାଇଁ
ହୁଁ
କୁନା ମହାକୁଡ ଆଦି ଲୋକଙ୍କୁ ଡାକି ଏହି ଲିଖିତ ରିପୋର୍ଟ ଦେଲି କି ମୋର ମାକୁ ଗ୍ରାମର ରୂପା ଜରେଇ A1 କନ୍ଦା ଜରେଇ A3 ଟସେ ଜରେଇ A4 ଓ ଭର ଜରେଇ A2 ମାନେ ମିଶି ମୋର ମାକୁ ତଣ୍ଟି ଚିପି ମାରିଦେଇ ନଦୀ ପାଣିରେ ଭସାଇବାର ଥିବାର ଦାବି ରଖି ଏତଲା ଦେଲି।
So on suspicion it has been given because they two
Previous
of
one.
them assaulted the
Previous one.
deceased. So that is how the FIR has been lodged against 4 persons.
ଆଜ୍ଞା
Okay. So how many witnesses have been examined? 15.
15
So Mr. Das, you say that no eyewitnesses to the offense.
Yeah.
So what are then what are the other circumstantial evidence?
confession confessional statement
Extrajudicial.
confessional
Yes.
Extrajudicial.
Before whom?
before Sarpanch and the
Who are they? PWs? So extrajudicial confession.
PW2
Just a minute. Extrajudicial confession
Shukla made an extra confession.
before PW
2
Suklal, right.
2, PW 2.
ex Sarpanch
हाँ आउ कौन गोटे एक्स्ट्रा जुडिशियल कन्फेशन आउ
leading to discovery
लीडिंग टू डिस्कवरी कौन
ସେ କଟାରୀ
डिस्कवर कटारी की एविडेंस दूची
ରୂପା A1 leading to discovery
नहीं सेटा होची A1 देची
A1
अच्छा अच्छा at the instance of A1 okay then
ତାପରେ ଡେଡ୍ ବଡି ରିକଭରି
डेड बॉडी रिकवर कौन आको इच्छा से ये जो 3 जन अपेलेंट और रहिले
ସେ ଯୋଉ ନାଇଁ ନଈରେ ଭାସିଲେ
नईरे बसला छड़ा
ନଈରେ ଭାସିଲେ
so far as these appellants are concerned, the main, as you say, it is the evidence of PW2.
PW2
Acha.
and
So,
in presence of other persons.
we'll go one by one. So let us read PW1's evidence. We'll go because one. Come to PW1. Then we'll go to PW. Yes.
I am the daughter of deceased Raimati.
Huh?
I am the daughter of deceased Raimati. PW1. On 26/9/1999 Saturday, my mother was died. A child of accused Bhakta died on Friday. And for that, the accused person assaulted my mother at about 3 p.m. By saying, "You made witchcraft to the child of Bharat." When the accused persons assaulted, out of fear, my mother went to the house of my elder father, Purna, and on chasing the accused persons assaulted her. Thereafter, my mother came to our house, and after taking dinner, he, myself, and my PUC, PW7, Sita, went to the house.
सीता कितने नंबर सखी
PW7.
PW7 तो आई
नहीं thereafter my mother came to our house and after taking dinner
mother
she
was
went
deceased.
she went to sleep to the
another
house
of
ours on Sunday morning.
Next, on Sunday morning, I, myself, and my PUC Sita
PW7
went to the house and
went to
found
that
That
house
house.
मैंने
that
जोटी
house.
सोई थी
and found the door was opened and also found my mother was absent. We searched for her, but did not get my mother. The villagers advised to inform the matter to the village chowkidar. Then we went to the house of ex-sarpanch Shukla, PW2, along with the village chowkidar. Then Sarpanch Shukla asked the whereabouts of my mother to the accused persons. At first, the accused person denied. Then the accused person again went to the house of ex-sarpanch Shukla and made extrajudicial confession by saying that they have killed my mother. Thereafter, they went to the PS and made a report about the occurrence. Orally, I reported Orally, I reported the matter to the police. Police reduced my oral report into writing. He read over and explained the contents of my report, and knowing fully well, I put my signature on my report. Exhibit 1 is my report, Exhibit 1 my signature. Cross examination. ସେଠି କହୁଛି ତାଙ୍କଠୁ ଶୁଣିଲା ପରେ ରିପୋର୍ଟ ଦଉଛି।
ये जो FIR रे एक्स्ट्रा जुडिशियल कन्फेशन जोटा रही पेज 35 रे सेटा लिखाई छि केवल रूपा जरे ही कहला बेल लिखाई छि तापर कोन लिखि जाई छि सेटा अछि के
original.
FIR एंड ना इनकी तो जो ट्रायल कोर्ट रिकॉर्ड टा दी
Good touch.
हां ना
এটা অরিজিনালটা না স্ক্যান করে
से जो कुहाउन एठी जे समस्ते कहले बेली thereafter we went to this one ये जो extra judicial confession विषय रे then so and so went to the then the accused persons again went to the house of so and so made extra judicial confession एठी लागुची जेमती as if केवल से जो रूपा लास्ट 4 लाइन देखंतु
ସେ ଚାଲେନ୍ ରୂପା ଜରାଇ କହିଲା
रूपा जरे
ସେମାନଙ୍କୁ ମୋର
कौन ये
कौन देई
माने
पचार-
किछ कहले बेल तो लिखा है नहीं बाय द वे सेटा रिपोर्ट देला तापर कोन ई क्रॉस एग्जामिनेशन का
only on the Friday the accused person quarreled with my mother. Thereafter there was no quarrel in between my mother and the accused person. On Saturday I slept in one house and my mother had slept in our another house. On Sunday we did not get my mother and thereafter we searched for her. I inquired about the whereabouts of my mother from the villagers, but they did not say about my mother. My younger sister and one person went to the village chowkidar. Thereafter, we reported the incident at the PS. To court. Before going to PS, I had been to the house of the sarpanch. That is a PW2. At first, the accused person denied to have killed my mother. When I went to the accused persons for the first time, and thereafter I went to my house. When the accused person went to the house of sarpanch, Uklal, again I went to the house of sarpanch. The house of sarpanch is about distance of 500 feet from the house of accused persons. It is not a fact that I am not pulling well.
I am not pulling on
well with the accused persons. On village Percy, I called the sarpanch as Jetha, elder father. The sarpanch is my own caste people, agnetic relative. I cannot say Odia well, so I also do not understand Odia properly. I have not given in writing to the police. Whatever I say, police reduce into writing. Police read over and explained the contents of the affair to me in Kolho language. I also reported the matter in Kolho language. I gave my signature on 2 papers before the police. It is not a fact that I have not stated before the police that accused persons chased my mother up to the house of Jetha and assaulted her there. It is not a fact that I have not mentioned in my report and not stated before the police that at first the accused persons denied the occurrence and thereafter they confessed their guilty before the ex-sarpanch of our village. At about 9 a.m. to 10 a.m., I had been to PS. The accused person confessed their guilty before the ex-sarpanch at about 7 a.m. The same day, at about 12 noon, police brought the accused persons to the police station. It is not a fact that due to the previous enmity, I had filed this case, false case, against the accused persons.
Come to PW2, let us see.
I have the Sarpanch in there 985 in our GP. I know the accused person, and deceased Raimani, alias Raimati. On 25/9/1999, PW1 and her PUC Sita, that is PW7, went to my house and they told me that they did not get the deceased after search. The village Chaukidar, the PW9 here, told me that the Sarpanch, he searched the deceased but did not get her. Thereafter, I myself, PW1 Sita, PW1 Sita and village Chaukdar went to the house of the deceased but did not get her. Thereafter, I came to know that the accused persons assaulted the accused deceased on the previous day. Hearing this, we called the accused persons through the village Chaukidar. On my question, the village Chaukidar denied.
No. On my question, the accused persons.
On my question, the accused persons denied by giving that.
Denied by saying
By saying that they had not assaulted Raimani or killed her. After some time, the accused persons told me that they had killed the deceased Raimani. Further, the accused persons, on my query, told me that they had thrown the deceased in the river. At the joint place of river Kathavaria and Basila. Thereafter, we went to the PS along with the PW1 and others. Cross-examination. At first, PW1 did not say me that the accused persons had assaulted the deceased. I directed them to search the deceased. Hearing the occurrence from PW1, I have called the accused persons to my house. I have not been to the house of the accused persons, but village Chaukidar had gone to their house and called the accused persons. At first instance, the accused person denied about the death of the deceased, though I had asked them twice. Till then, the accused person had denied about the whereabouts of the deceased. Thereafter, I said the accused persons that if the matter will be reported, then the matter will be complicated.
From within they are denied and again this thing. Okay.
Denied about the death of the deceased.
Although be voluntary one, Mr. Okay, read it out.
If the matter will be reported, then the matter will be complicated. I told the accused persons, then subside the matter in the village about the assault on deceased. That is, if the deceased will be available at about 9 AM, village Chaukdar called the accused persons to my house. My house is at a distance of 1,000 feet from the house of the accused persons. The accused persons remained before me for a period of 1 hour. At that time, the Chaukidar was present, PW9, present in my house. I have been asked about the occurrence by the police. It is not a fact that I have not stated before the police that the accused person confessed before me by saying that they have killed the deceased. And on my query, the accused person told me that they had thrown the deceased in the joint place of river Kathavaria and Basila. Though we had been to the said river, still then we did not get the dead body. Chaukidar, PW1, along with some other villagers and Sita, had been to the bank of river. The accused persons were my party person. It is not a fact that the accused persons were propagating against me in the Sarpanch election. And for that, I have created this case against the accused persons through PW1 and others. At this stage, additional PP, we shall recall the witness and the
examiner.
While the accused Rupa was in police custody, he has concealed the Kotari. He has stated that he has concealed the Kotari, weapon of offense. Accused Rupa led me and police and gave recovery of the Kotari from the Milan place of river Kathavaria and Govindapur. Police seized the Kotari and prepared the seizure list. Exhibit 2, my signature that. The other accused persons were not present when the accused Rupa Jare was present at the time of seizure. MO was inside this MO1
And
was
of the
seized.
joint rivers of
Sand of the joint river bank. MO1 was kept in the sandy place. At that time of recovery, M1 village GR
At the time of recovery of MO1,
village GR accused Rupa and Govinda Gagre
Gagarai.
went to the other side of the river and they searched MO1 and accused Rupa brought the MO1 from the sand. Police and Manso were in the other side of the river. I know that police mentioned it too that the Qatari was seized, but I cannot say the other contents of Exhibit 2. It is not a fact that the accused Rupa confessed before me that he had concealed the Qatari and had not given recovery of the same to the police. It is not a fact. I have not stated before the police that accused Rupa confessed before the police that he had concealed MO1 in the meeting place of river Kathavaya and Govinda and gave recovery M1 from the sand.
So as it appears from this evidence that when the accused persons were called because they had assaulted the deceased one day before, or let us say 2 days, because the assault part took place on Friday, and this extrajudicial confession is stated to have been made on Sunday. Because on the morning, the deceased was not found. They searched here and there, did not found. They reported, and then the accused persons were called, and the accused persons denied. That is the evidence. At first, the accused persons denied about the death of the deceased, and they were asked twice about this. Till then, the accused persons denied about the whereabouts of the deceased. Thereafter, PW2 says, I said the accused persons that if the matter will be reported, then the matter will be complicated. So this clearly takes out it from the purview of that voluntariness.
The only things that they have reported, because it is brought to when it is brought to the notice of the PW2, being the Sarpanch who want to subside the issue and came to know. When they are denied, specifically denied.
Sometimes extrajudicial confession is that
voluntary.
After the commission of the crime, he is in remorse, he repenting, and a confidence is reposed on some person, and before him he disclosed. And but here it's something different. The chowkidar, this man who is the sarpanch, they are calling him in front of others. They are asking him. They are repeatedly denying him, and then again this is a kind of, you can say that is a kind of trait also, that जदि न ये करिवो तुमको ओडिया रे जदि एटा को ये करा जीवो ताले देखो तमे जदि न कहिवो ताले मैटर को हमें पुलिस को रिपोर्ट कर देबू आ मैटर टा बहुत कॉम्प्लिकेटेड है जीवो. तो
no, despite that they have not said.
तापर हाँ कहउछन पुनी देखो, I told the accused person that I can subside the matter in the village.
Yes.
तो तापर भी ए जिंस आसुची पुनी.
That is the, otherwise had it been the question of only police, probably we could have taken.
So
discrepancy रोज FIR देला से कथा कहू नहीं जा से एठी तो PW ने एग्जामिन से बेटी कहू जे
FIR रे टोटली समस्ते माने ए जो दी जण ए जो माने अछंती ए माने कन्फेशन करिसंती बोली नाही. इट्स वेरी क्लियर इट लिखा है
पर्सन कन्फेस्ड. हां ओटी जा सब जगह रूपा कन्फेस्ड, ऑल अदर एक्यूज पर्सन्स कन्फेस्ड.
नहीं से पर दिस FIR after the confessional statement, so-called confessional statement was made, the report was lost, and the FIR very clearly देखौची author सेठी पासंतु एहा परे गोपाल जेराई भिणोई हेला PW5 ग्रामर कुना कुना महालिक आपण पूरा कहले चौकीदार एग्जामिन हिज बोली
9
PW9
और मना करछंदी
9
अच्छा अच्छा PW9 ଏବଂ ସୁଦର୍ଶନ ପାଖରେ ହେଲା PW6 ଆଦି ଲୋକଙ୍କୁ ଡାକିଲୁ ଅନ୍ୟମାନଙ୍କର ବୋଧେ ସମସ୍ତ ଘଟଣା କହି ସେମାନଙ୍କୁ ଧରି ପୁରୁଣା ସରପଞ୍ଚ ଏଇଟା ହଉଛି PW2 ଏଇ ଯୋଉ ଘର ପାଖକୁ ଯାଇ ମୋର ମାଙ୍କ କଥା କହିଲୁ କ୍ଲିୟର ଆମେ ତାଙ୍କୁ ରୂପା ଜରାଇ ଭରତ ଜରାଇଙ୍କ ଘର ପାଖକୁ ଯାଇ ଶୁକ୍ଲାଲ ଜେନା ମିନ୍ସ PW2
ନାଇଁ
ଶୁକ୍ଲାଲ is PW2 ସରପଞ୍ଚ
before whom the confession
ହଁ ଶୁକ୍ଲାଲ ଜେନା ସେମାନଙ୍କୁ ମୋର ମା କଥା ପଚାରିଲେ ଏପର୍ଯ୍ୟନ୍ତ କ୍ଲିୟର ଦେଖା ହଉଛି ଏ ଯୋଉ ଇଏରେ ତାପରେ କ୍ଲିୟରଲି ଲେଖା ହେଇଛି FIR ରେ ରୂପା ଜେରାଇ କହିଲା ଯେ କାଲି ରାତି 2ଟା ବେଳେ ଆଉ କଣ ଲେଖା ହେଇଛି ଏଟା ନାହିଁ ଏଟା this is so this indicates that whatever अच्छा यार ये थी वो केस डायरी थी वो केस डायरी
रूपा जराई रो कन्फेशन भी अछि before the police at page 82
केस डायरी इंग्लिश यूज कर लो
रूपा जराई भी ये देती ना
confession से
नहीं
लीडिंग टू डिस्कवरी
हां कटर
इट एटा लेखा है एटी देखंतु
अदर साइड ऑफ
केस डायरी तार इंग्लिश ट्रांसलेशन टा अछि among them Rupa Jarai confessed before them that on 25/9/99 night they all killed Swanso by throwing the dead body in the on key water river Swanso. So this is on this information they went to the river and searched for her mother, but they could not trace out the dead body of her mother. Then she along with others came to the police. So this is very clear. So the man who has confessed is Rupa Jarai. He stated that he along with others. So it is not the confession of these three persons.
No, only Rupa Jarai.
So now
in other witnesses those are stated other all accused persons but not named. Other accused persons but not named by specifically XYZ.
So the extrajudicial confession is made before PW2, then PW9 perhaps
9
or anybody else
4 basically
4 अच्छी 9 देखी दबा 3 तो किसी कहलानी ये इनक्वेस्ट रिपोर्ट 4 कौन पहुंची देखो ना आसुन गोटे देखी दबा
नहीं 4 नहीं
4 टा पढ़ी दियो कौन से को पॉइंट रे पढ़ी सकी ना
नहीं 4 नहीं
नहीं PW4 टा पढ़ी दियो
I know all the accused persons and also the deceased Raimani on the Sunday morning while I was sitting in the veranda my house one Gopal Jarai came to me and told me that my mother-in-law Raimani was not in her house. Thereafter I myself PW1 PW2 and other went to the PS. Thereafter PW1
lost report at PS.
The deceased is my mother-in-law. At the instance of police, I stayed in the police campus till night. At about 12 midnight, 2 persons came to the PS and told the police that one dead body was floating in the river near village
Ramjali.
Gramrakshi of Kothabaria,
Ramjali, constable and others went to the place where the dead body was floating. And the next day, the OIC Badam Pahad, PS and other went to the spot and made inquest over it. Police sent the dead body to the police.
So this evidence is not that relevant. It's come to the next one. PW5.
Kitchen 9.
7
6 भी किसी नहीं तापरे 7
I know all the accused persons. That the witness unable to speak. I know the accused person. This is Raimati is my bhauja, brother's wife. last rainy season, on the day the accused person assaulted the deceased, on the next morning I found the deceased did not in her old house. In the old house, the deceased was normally sleeping. Thereafter, we called the ex-sarpanch of the village. Sarpanch asked about the occurrence to the accused persons. The accused person confessed their guilty by saying that they had killed the deceased Raimoni, Raimoti alias Raimoni. They had thrown the dead body in the river. I went to the PS along with PW1, Sarpanch and others, and PW1 orally reported.
This is contrary to FIR, no?
Yes.
Yes.
Yes. When
the accused person quarreled with the deceased, at that time, many persons of the village were gathered. I cannot say the name of the persons who were present. There are 20 to 30 persons who were there. After the quarreling, the accused persons went to their respective house, and also the deceased remained in her house. When we did not get the deceased, then we went to the Sarpanch. Sarpanch also directed us to search the deceased again. At first, Sarpanch called the accused persons to our house and asked about the occurrence. Occurrence to them, but the accused person denied the occurrence. Thereafter, again, the Sarpanch called the accused person to house. When the Sarpanch called the accused person to his house, at that time, I was also present in the house of Sarpanch. Police did not ask me about the occurrence of police. It is not a fact that I have not.
It is not a fact that
It is not.
I have not stated before the
I have not
police.
stated before the police that a Sarpanch called the accused persons, and the accused person confessed their guilty before him by saying that they had killed the deceased, and the deceased person had thrown
And the accused person had thrown
the accused person had thrown the dead body in the river. It is not a fact that I am not pulling on with the accused persons. It is not a fact that due to inimical terms with the accused persons, I am deposing falsely. It is not a fact that accused persons have not confessed guilty.
Okay. Next,
PW8.
PW8.
Kitchen.
Deceased is my mother. I know the deceased accused deceased is my mother.
But she is not.
My mother died on Saturday night.
Mhm.
We searched my mother, but did not get her. Thereafter, we went to the house of the Sarpanch, Suklal. We called the Gram Rakhi and then went to the house of Sarpanch. At first, the accused person denied about the occurrence with Sarpanch. Thereafter, the accused person confessed their guilty by saying they had killed the deceased Raimati and thrown the dead body in the river. Cross-examination. I am staying in my father-in-law's house. My house is at a distance place from the house of the deceased. When my sister told me about my mother, thereafter I came to the spot from the house of my father-in-law. When we did not get my mother, we came to the house of the Sarpanch. When the accused person denied, then we went to the PS, to court. The accused person confessed their guilty before the Sarpanch and us. PW4 is my husband. My husband was present when the Sarpanch, when we searched for this deceased, and when the
went to PS.
Went to PS.
I have not
stated
stated about the
the confessional statement of the accused persons before my husband. The Sarpanch asked the accused person in his house. The Gram Rakhi called the accused person to the house of Sarpanch. I have been examined by the police after 3 days of the occurrence. It is not a fact that I have not stated before the police. PW2 asked the accused persons about the occurrence, and the accused person confessed their guilty too. Again, she says she has not stated before the police that the accused person confessed their guilty before PW2, as police did not ask her, and the accused person had thrown the dead body into the river. For the first time, I am deposing about the confessional statement of the accused persons in the court today, and had thrown the dead body in the river. PW7 is my PUC. I do not understand Oriya language such and such. PW9 the grammar. I know all the accused persons and also the deceased Raiman. I am the Gramaraki of my village, Kathabaria. The son of the deceased and one Matal Hambram told me that in the last evening, the accused person assaulted the deceased, and today she is not found. I myself, PW2, Sudarshan Gagrai, were present at the time the accused person did not agree about the occurrence. Thereafter, again we asked the accused persons about the occurrence, and they confessed by saying that they had killed the deceased and had also told to have thrown the dead body in the river. Thereafter, PW1 and Sita went to the police station to report the matter. Then I myself and one constable went to the search for the dead body. We got the dead body in the meeting place of Jalpa and Kanhu rivers. Cross-examination. I was informed about the occurrence at about 7 a.m. I myself, Suklal and Sudarshan Gagrai, son of the deceased Rupa Jore, went to the accused persons for interrogation. At first, the accused persons denied about the occurrence. We interrogated the accused persons in the house of the deceased. Thereafter, the accused person confessed they are guilty in the house of the deceased, and then they also confessed they are guilty in the house of PW2, Suklal. Except the above named person, no other person were present when the accused person confessed they are guilty. I took the accused person to the house of PW2, Suklal. I had also asked the accused persons about the occurrence in the house of PW2. Thereafter, we directed PW1 to inform the matter at the PS. I have been examined by the police after 2 days of the occurrence. It is not a fact that I have not stated before the police that on my interrogation, the accused persons confessed their guilt. I also talked with the accused persons in Kolho language. Also the accused persons confessed they are guilty in Kolho language. One constable was present with us. The name of the constable is Yogendra Sadhu. At present, I am the Gramarokhi of the village Kathavadia. It is not a fact that the accused persons have not confessed their guilty before me and others, and they had thrown the dead body in the river. And at the instance of the IO, I am depositing today in the court. At about 8 a.m., PW1 went to the police station. Half an hour will take if one will go to the PS from my village. At about 11 a.m. on the same day, the OIC went to the village of the deceased for the purpose of the investigation of this case.
Next.
In PW14, doctor. And PW15, the IO.
What is your name? Madhyam.
PW14, my doctor.
Mhm.
On 28 I was OG specialist at SD hospital at Rairangpur. On that day, on police requisition, I have conducted the PM examination over the dead body of the Raimoni Jarei, wife of late Gopinath Jarei, of village Kathavadia, PS Badampad, Mayurbhanj, and found the following injuries. Head and the rest part of the body brought separated. The decapacitated head fixed with the body at the neck. Body was swollen and decomposed. On examination of the decapacitated
head thila sir.
head,
Decapitated head.
हाँ,
अच्छा. Next to the body. अच्छा.
eyes closed, face swollen, skull intact. On dissection of skull, brain and the membrane intact. The penetrating injury of the size 33 cm into 2 cm into 1 inch on the lower part of the face of right side just above the mandible. Another penetrating injury of size 3 cm into 3 cm into 1 inch on the left face, 2 cm from the angle of mouth. On examination, the dead body swollen, foul smelling, discharging from anus and vagina. Papu and maggot present on the body. Abdomen descended. On dissection, tracheal arises, major vessels in the neck completely divided. On dissection of thorax, heart and lungs are intact. On dissection of abdomen, stomach descended, contains 2 ml of digested food. Small and large intestine are descended. Spleen, liver, kidney, and bladder found intact. The injury is all antemortem nature. The cause of death was due to precapitation of head, probably by sharp cutting weapon. The time of examination since death was 48 to 78 hours.
This
And
is actually, it goes to contrary to the extrajudicial confession. Extrajudicial confession houchi, Rupa Janne confessed that they killed by throttling and then threw the dead body. This is something different.
if
penetrating injury, dita penetrating injury.
Cautery, the seizure of cautery, cautery was seized. Cautery was seized at the instance of Jupajare.
The extrajudicial confession which is given in the FIR and before the that witness PW1, that is तार येटा English translation एटा कम उड़ियाटा ये तो सेट में हमें पढ़ी हुए थे जे रूपा जेराई confessed before them that on 25/9/99 night.
LRC may kind of the confession statement before the police.
अरे एठी देखो the initial stage रे तांकरो येटा होची by throttling and threw the dead body in that was the confession. So it goes contrary to the medical evidence. It's not a case of throttling. It's a case of some sharp cutting weapons were used. Penetrating wounds were caused.
He has admitted in the confession before the police.
Can it taken? That's it.
If the injury sustained.
No, that confession is a confession.
Not
so what we see that even if your FIR,
nobody was seen the occurrence.
No, that is why the circumstantial evidence, and one of the circumstances.
Once it is found,
you are relying on extrajudicial confession. That extrajudicial confession, mode of death of the deceased has been mentioned, which runs contrary to the PM examination report. That is what we want to show. And that is by one. As per the FIR, it is by one. But in the during course of evidence, you have stated that all other. And admittedly, as your case shows that after the confession was made, he went to the police station. So if he is mentioning about the extrajudicial confession, everybody confessed, then he could have mentioned that all confessed. But he specifically stated that earlier they denied, and then amongst them Rupa Jarai confessed.
And the confession is also not consistent to the medical evidence.
And,
here there is number of injuries.
At least two penetrating wounds.
And most importantly,
decapitation माने sharp cutting weapon. If कौची doctor कौचन sharp cutting weapon रे injury है. आपनकर confession रे sharp cutting weapon use होबारो भी नहीं. खाली कहिची throttling है कि नहीं. हम throttling करी कि नहीं ताकू पपाड़ देलु.
Suppose while deposing confessed before the Sarpach and others, they have suppressed something in the reality.
No. It's a question of circumstantial evidence, and it's not a direct evidence. Circumstantial evidence रो जो standard of proof दरकार, अपन जो 5 golden principle that could satisfy upon कोची. And X is, suppose let us say that X has made extrajudicial confession in which he himself also implicates along with others. So that is under section 30 of the Evidence Act, and that is to be taken off as a last resort. That of quoted decision of that 5-judge bench, 64 Supreme Court Haricharan Kurmi case is the leading decision that extrajudicial confession of a co-accused is not a substantive piece of evidence. It is to be taken as last. Others' evidence has to be taken first. From that, if the court says that found that yes, the guilt of the is established, it can be taken as an additional. You cannot start with this evidence. So even if this man has this Rupa Jarai has confessed implicating himself and others. So we cannot start with others. We have to see what are the other materials on record to justify the guilt.
The entire
And
case
when-
revolve around this.
And you are
There is
seeing
no other circumstance.
no.
Only quarreling.
It is
Yeah.
true that inculpatory statement is there, but at the same time, she is speaking about anyway. But the consistency with regard to the voluntariness of the witness is also a question here. At different stages,
Different changes.
they have been asked.
They have called and asked them.
So what is the other evidence of that?
No,
Nothing.
nothing.
Only basing on this extrajudicial
Yes.
confession.
ଇଏ ଆଉ ସେ ଯୋଉ କନଫେସନ ହେଇଛି PW2 ର ଏଭିଡେନ୍ସ ଦେଖିଲେ ପ୍ରଥମେ ମନା କଲା, ଦ୍ୱିତୀୟରେ ତାକୁ ଡକା ହେଲା, ଡକା ହେଇକିନି ତାକୁ କୁହାହେଲା ଯେ ତମକୁ ଯଦି ନ ଇଏ କରିବ ତାହେଲେ ରିପୋର୍ଟ କଲେ ଅସୁବିଧା
Complicated
ହବ
ହବ.
ଏବଂ ତାପରେ
ଆମେ
କହିଛି ଯେ ଆମେ ଯଦି ତମେ କହିଯିବ ମାନେ ଦେନ୍ ମ୍ୟାଟରଟାକୁ ଆମେ ସବସାଇଡ କରିଦେବୁ।
Extracted from them with a hope that the
Ah,
matter.
So there is an allurement to subside.
ହଁ
Had it only been the question that the matter will be reported to police would not have probably, but now that they say that will subside it. So there is an
They have
allurement.
confessed with a
So
good
after
faith.
the insistence, they have allured so that they have spoken. And that is also discrepant. What is said by Rupa is not the medical evidence.
ମେଡିକାଲ ଏଭିଡେନ୍ସ
Had
Medical
this
evidence.
consistency been there, probably you could have said that yes, there is a consistent confessional statement, irrespective of the fact whether the voluntariness is there or not. But that is also not there.
ଆଉ କିଛି ନାହିଁ।
ଆଉ କିଛି
ନାଇଁ ଜଜମେଣ୍ଟ ଦେଖିଲେ କଣ କହୁଛନ୍ତି?
ଜଜମେଣ୍ଟଟା ଦେଖନ୍ତୁ କଣ କୁଆଡେ ଥିବ କଣ
ଜଜମେଣ୍ଟ
ଆଉ କଣ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ଛଡା ଆଉ ସେ ଯୋଉ 2 ଦିନ ପୂର୍ବରୁ ଯୋଉ ଆସଲ୍ଟଟା ହେଇଥିଲା ତା ଛଡା ଆଉ କଣ ଅଛି?
ସବୁ ତ confession ରେ ଯାଇଛି on the same day about 9 AM para 6 17
ନାଇଁ କୋଉଠି ଜଟେଡ ଡାଉନ କରିଛନ୍ତି କି these are the
Para 5 is quoted, the
circumstances.
prosecution must have to prove the following points whether the accused persons in furtherance of their commitment. This is general.
କହୁଛନ୍ତି ଯେ it is seen that no one had seen the actual assault. So that is no dispute. It's a case based on circumstances. So the prosecution relied mainly on extrajudicial confession of the accused. ତାପରେ evidence create କରି extrajudicial confession discuss କରି ଏଇଟା ଟିକେ discussion ଟା ଟିକେ ପଢିଲେ ଟିକେ ଦେଖିବା paragraph 7 ଟା ଟିକେ ପଢିଲେ judgment ର
Now let me discuss.
ସେ ଯୋଉ extrajudicial confession paragraph 7 of the paper book, page number 15.
Now let me discuss after the evidence of PW1, 2, 7, 8 and 9 would be believable. PW1 has specifically mentioned on the body of the affair that on 25 November, the daughter of the accused Bharat Jare died in fever. Seeing the death of the accused Bharat Jare seeing the death of the child, accused Bharat Jare and other accused persons came together and challenged the deceased as to why she had killed the child by applying witchcraft. And they quarreled with the deceased and gave fist blows and slaps on the face of the deceased. After taking dinner, the deceased went to sleep in her old house, which was at the distance of 300 cubits
From the new house.
from the new house. On morning, PW1 and PW7 did not get the deceased. They suspected the accused person and thereafter, in presence of the ex-serpents, PW2, all the accused person confessed their guilty by saying that they had killed the deceased by throttling and had thrown the dead body in the Jalap river. In evidence, PW1 has stated that on Friday, that is on 25 November, the deceased was assaulted by the accused persons. After taking dinner, the deceased went to sleep in the old house, and on morning, C and PW7 did not get the deceased in the old house, and thereafter they informed about the missing of the deceased to the local Sarpanch, Shukla, and village Chowkidar. Then Sarpanch asked accused persons, the accused person did not agree Thereafter, the accused person voluntarily again went to the house of Shukla and on extrajudicial confession by saying that they had killed the deceased, and thereafter PW1 orally reported the matter to the police station by an Exhibit 1.
Just a pause here, yes.
That is the
It court ଆସିଲା where 47 asking.
ଚୌକିଦାର ନେଇକି ନାଇଲା ତାଙ୍କୁ
ଆଜ୍ଞା
Thereafter, the
Sir,
accused persons voluntarily again went to the house of
that I have marked.
ଭଲ ଅଛି ପଢନ୍ତୁ ତାପରେ
In cross-examination, she has stated that only on Friday the accused persons had quarreled with the deceased. On Saturday, she slept in one house and her mother had slept in another house. On Sunday, she and other did not get the deceased, and she and her younger sister informed the matter to the village chowkidar and the ex-sarpanch. At first, the accused persons denied to have killed her mother. And thereafter, the accused persons went to the house of Shukla and confessed their guilt. However, perused the evidence PW1 and found our evidence has not been seconded by the learned counsel for the defense. PW2 has stated that he was the sarpanch in the Gram Panchayat, in his Gram Panchayat in the 1985. On 25/9/1999, PW1 and her PUC, Sita Zare, informed him about the missing of the deceased. The village Gramoraki told him he had also sought the deceased, but he did not get her. Thereafter, he himself, PW1, Sita Zare, and village Chowkidar went to the house of the deceased, but did not get her. Thereafter, he came to know that the deceased persons had assaulted
the accused
persons assaulted the deceased on the previous day. By suspecting the accused person, he called him through the village chowkidar. On his question, at first, the accused person denied, and after some time, the accused person told him that they had killed the deceased, Raimati Jarai, and had thrown the deceased on the meeting place of a river.
So it's not voluntary, you see that ଚୌକିଦାର ଗଲା ତାକୁ ଡାକି ନାଇଲା PW2 ନିଜେ କହୁଛି ହଁ
Again, in cross-examination, he has stated that hearing the occurrence from PW1, he called the accused persons to his house through the village chowkidar. At first, the accused person denied about the death of the deceased, though he had asked him twice. Thereafter, he said to the accused persons that if they will confess the guilty, the matter would be reported at
correct
PS, and he will subside the matter in the village about the assault of the deceased. On the same day at about 9 a.m., the accused person came to his house and confessed their guilty by saying that they had killed the deceased. Further, the accused person told him that they had thrown the deceased in the meeting place of river Kathavaria and Basila. However, the learned defense counsel has not at all seconded the evidence PW2. The sarpanch, Gramoraki, and others have not threatened or made any coercion to the accused persons to confess the guilty. But the other hand, the free will of the accused persons and confess their guilty by saying that they had killed the deceased and had thrown the dead body in the river. PW7 has stated that the deceased is her bhauja. When she did not get the deceased in her old house, at that time, she herself, PW1, informed about the whereabouts to the sarpanch PW2 of her village. The accused person confessed their guilty by saying that they had killed the deceased and had thrown the dead body in the river. In cross-examination, she has stated that when she did not get the deceased, then she and others went to the sarpanch. At first, the sarpanch had been to the house of the accused persons, and the accused person denied the occurrence. After some time, the accused person came to the house of sarpanch and confessed their guilty, and at that time, she was present along with the PW1. However, the London Defense Counsel has not at all seconded to the evidence of PW7. PW8 has stated that when she and others did not get the deceased, she reported about the whereabouts of the deceased to the ex-sarpanch Shukla, Gramoraki. At first, the accused person denied the occurrence to the sarpanch, and thereafter they confessed their guilty by saying that they had killed the deceased Raimati Jarai and thrown the dead body in the river. In cross-examination, she has stated that Her house is at a distance place from the house of the deceased. Hearing the occurrence from her sister, field 1, she came and did not get the deceased in the house. She herself and her husband had also searched from the deceased. In para 4, she has stated that accused person had confessed their guilty before PW2. However, the Learned Defense Counsel has not at all seconded the evidence PW8 regarding the extrajudicial confession of the accused persons. PW9 has stated that he was the village grammar and at the instance of PW1, he herself, PW2, Sudarshan Jari, went to the house of the accused person. They did not agree about the occurrence. After some time, again the he and others asked the accused persons, and the accused person confessed their guilty by saying that they had killed the deceased and had thrown the dead body in the river. Thereafter, PW1 and 7 went to the police station. In para 2, he has stated that the accused person confessed their guilty in the house of the deceased. Then they also confessed their guilty in the house PW2. So PW1, 2, 7, 8, and 9 have clearly stated that the accused person had confessed their guilty before them by saying that they had killed the deceased and had thrown a dead body in the meeting of the river Katavaria and Basila. Already I have discussed that the Learned Defense Counsel not at all second their evidence. PW15 has stated in para 7 the evidence that PW1 has not mentioned in her affair and not stated before him. All the accused person confessed their guilty of PW2 before PW2 and had killed the deceased by throttling and had thrown the dead body in the river. PW2 has stated before him that he called the accused persons and accused Rupajari admitted before him that he and other accused persons killed the deceased and had thrown the dead body into the river. PW8 had not stated before him that all the accused persons had confessed their guilty before PW2 and had thrown the dead body into the river. But she has stated that accused Rupajari had confessed before him that he and other accused persons had killed the deceased and thrown the dead body in the river. So before PW15, PW1, 2, and have stated only accused Rupa had confessed that he and other accused persons had killed the deceased. On the other hand, in evidence of PW1, 2, 7, 8, and 9 have stated that all the accused persons confessed by saying that they killed the deceased and had thrown the dead body in the river. Though the above noted witnesses have not implicated the other accused persons except accused Rupa Jarai in extrajudicial confession before PW15, still then all the accused persons had confessed their guilty before the witnesses. However, the Learned Defense Service has answered.
He has held that the confession is a true, free, and voluntary one on the face of the evidence of PW5.
All these things has repeatedly been stated in the law.
Baki one Kotari, that discussion starts is a Kotari has been recovered at the instance of that Rupa. So
para 13 ने common intention and 34 to 1.
नहीं ये अच्छी किछि पटारी जो हल्ला ब्लड स्टेन किछि पता तो नहीं एसएफएसएल किछि नहीं रिपोर्ट
बाली रे पोता आइतला बाहरला
नो
एटा भी चाहिए एसएफएसएल
नहीं पेट्रोल दिस recovery has been given. What is the nexus with the crime? Because there is no statement to that effect. Whereas the court has appreciated the evidence saying that while giving the confessional statement, they say that we threw the body beheading. That is not the statement. Nowhere. They simply say that
Since taking into account
they
the
throttled
previous,
and threw the body.
taking into account the previous call, and thereafter the the person deceased was missing from our house, and after confession is brought that this is they have thrown. In connecting all those three.
No, that you have, that they could, the court could have connected it, provided someone has seen them last in the company of the deceased. Had the accused person been seen in the company of the deceased last,
Or near his house.
then probably this would have been. So lasting theory is not there.
Blood was also not detected in that.
Blood detected,
not detected in that Kottari, which is marked as P. There is nothing, and
ଗୋଟିଏ ଲୁହାର କୋଟରେ ଯାହାର ଲୁହା ବେଣ୍ଟ ଥାଏ ଲମ୍ବା ଧାରର ମଝିର 2 ଇଞ୍ଚ ଅଗ ପ୍ରାୟ 2 ଲମ୍ବା କାଦୁଅ ଓ ରକ୍ତ ଭଳି ଲାଗେ।
one Kottari marked as P. Report as C. Blood was not detected in the exhibits B and also stone.
ପାଣି ଭିତରେ ଯାହା କନଫେସନ ସିଏ କହିଥିଲା
କୋଉଟା କି
ଉପାଜରେ ଯୋଉ ବିଫୋର ପୋଲିସ ଯୋଉ କହିଥିଲା ତା ପାଣି ଭିତରେ ହାଣିଥିଲେ
ପୋଲିସ ପାଖରେ କହିଥିଲେ
ସେଇଟା
କନଫେସନ ବିଫୋର ପୋଲିସ ନହେଲେ ଏଇଟାକୁ କେମିତି ସେମାନେ କରିବେ ବେଡିଂ ଟା ତ କନଫେସନରେ ଆଣି ନାହାନ୍ତି।
କାରଣ ଆପଣଙ୍କର initial story by initial confessional statement as mentioned in the FIR is throttling କରି ତାକୁ ନଈ ଭିତରକୁ ଯେମିତି ପକେଇ ଦେଲେ but case ଦେଖିଲା ବେଳକୁ develop ହେଲା ଯେତେବେଳେ dead body ମିଳିଗଲା dead body ରେ ଦେଖାଗଲା ଯେ PM report ରେ ଆସିଗଲା ଯେ beheading ହେଇଛି ଆଉ ବୋଧେ penetrating wounds ସବୁ ରହିଛି ସେଇଠୁ କଟାରୀ କଥା ଆସିଲା କଟାରୀ କଥା ଆସିକିନି କଟାରୀ ଏମିତି ହେଲା ଏ ଯୋଉ କନଫେସନାଲ ଷ୍ଟେଟମେଣ୍ଟ ହେଲା ତାକୁ ବିହେଡ୍ କରାହେଇଛି ଏଇ ଜିନିଷ ଗୁଡାକ ପୁରା ତାକୁ ସବସିକ୍ୱେଣ୍ଟ ବଟ୍ ଇନିସିଆଲ ଷ୍ଟେଜରେ ଆପଣଙ୍କର FIR ଷ୍ଟୋରି କହୁଛି ଥ୍ରଟଲିଂ କରି ଫୋପାଡ଼ିଲୁ ଆମେ ତା ଡେଡ୍ ବଡିଟାକୁ।
And that is also the statement initially from the statement of the witnesses that confession was only for throttling and
throttling.
ସେଟା ତ ବାହାରିଛି ନା କନଫ୍ରଣ୍ଟ ହେଇକିନି ଆଇଓ ଜରିଆରେ ଆଇଓର ଦେଖାଉଥିଲା ଆଇଓ
15 ନା
ହଁ ପେଜ ନମ୍ବର 80 ଦେଖନ୍ତୁ ପଳେଇ ଆସନ୍ତୁ paragraph 7
in the in FIR it has been mentioned that
ଉପଜରେ confessed guilty
ହଁ ଏଇ ଯୋଉ କଥା
and other guilty by throttling
he and but confession is made by Rupa eta confront kari bahar karichanti PW1 has not mentioned in the FIR not stated before me that all the accused person confessed before PW2 that they killed the deceased by throttling and had thrown the dead body eta agala PW1 ro samast PW2 has stated before then he called the other and accused Rupa admitted before him that he and the other
Rupa
नहीं ବର୍ତ୍ତମାନ ଆପଣ ଟ୍ରାଏଲରେ ଯେହେତୁ ସମସ୍ତଙ୍କୁ ପୁରେଇଲା ନା ଯୋଉ ଅଲ୍ ବେଲି ସେଇଥିପାଇଁ ତାଙ୍କୁ କନଫ୍ରଣ୍ଟ କରିକିନି ଏଗୁଡାକ ବାହାର କରିଛନ୍ତି ତାପରେ ଦେଖନ୍ତୁ PW8 has not stated before me that all the accused persons had confessed the guilty before PW2 and thrown the dead body so and so but she has stated that accused Rupa had confessed. So that was the case, your FIR story and the statement given by the witness is that. But during trial, you all taku lagay dele, samaste confess kar dele.
Taking into account the previous call with the all the members, the court has inferred that 34 anla jehetu.
Hmm?
The 34 aniyaku para 13
No,
the previous call
the quarrel that took place, that was on Friday.
preceding
And nothing happened on
Saturday.
Saturday. That is the evidence as also come. Saturday night रे से ଶୋଇଥିଲା ବୁଢୀ ଗୋଟେ ଘରେ ଶୋଇଥିଲା ଏମାନେ ଆଉ ଗୋଟେ ଘରେ ରବିବାର ଦିନ ସକାଳୁ ମିଳିଲାନି ଆଉ
So the time gap is also too long to say that there was a
Immediate
any
quarrel
chance
happened.
that the accused persons could have been seen at that place and none else was there.
ଆଉ ସେ ଶୁକ୍ରବାର ଇନସିଡେଣ୍ଟ ପାଇଁ କିଛି ଚାର୍ଜ ହିଁ ନାହିଁ
କିଛି ନାହିଁ
ମାନେ even if 323 ବା ଇଏ ସେମିତି
at least blow ଅଛି ଇଏ ଅଛି
କିଛି
there is
ନାହିଁ।
a quarrel.
only 302 crore. This criminal appeal has been filed by 4 appellants, namely Rupa Jerai, Bharat alias Krishna Jerai, Ghasiram Jerai, and Jagmohan alias Taso Jerai, challenging the judgment and order dated 21/6/2000 passed by the learned additional session judge Rairangpur in ST case number 7/26 of 2000 in convicting them under section 302/34 and 201/34 of the Indian Penal Code and sentencing each of them to undergo life imprisonment under section 302/34 and RI for 3 years under section 201/34 of the Indian Penal Code and directing the sentences to run concurrently. Stop. The appellants were charged under the aforesaid offenses on the accusation that in the night of 25th September 1999 at Kathobaria, they committed murder of Raimati Jerai, bracketry hereafter the deceased, in furtherance of their common intention and knowing that the offense has been committed, they caused certain evidence connected with the said offense to disappear, to screen themselves from legal punishment in furtherance of their common intention. Stop. As per the prosecution case, as per the first information report lodged by PW1 Sasmita Jerai before the officer in charge of Badam Pahad police station on 26/9/1999. In short, is that his father Gopinath Jerai died since 5 to 6 years prior to the lodging of the FIR, and the deceased was her mother, and she, along with her
maternal and
সান্ন ভাই রূপেন্দ্র যারা এক্সামে নিয়েছি she along with her younger brother Rupendra Jarai and aunt Sita Jarai with the examination PW7 were staying together. We were staying in joint mess along with the deceased mother. On 25/9/99, the female child of appellant number 2, Bharat Jerai, fell ill and died for which the appellants suspected that the deceased has practiced witchcraft, for which the daughter of appellant number 2 died. And accordingly, they challenged the deceased and quarreled with her, and also assaulted her by fist and slaps. The informant, bracket PW1, her aunt, bracket PW7, and the co-villager Jatia Jerai PW11 subsided the dispute, and thereafter the deceased came back home, and all of them took their dinner and went to sleep. The deceased slept in a room separately, which situates at a distance of 300 yards from the house where where PW1 and PW7 were residing. On 25/9/99 night, in the early morning hours of 25/26/9/99, when PW1 and PW7 went to the house where the deceased was sleeping, they found the deceased was not present there. Accordingly, they searched for the deceased at different places but could not locate her. They intimated about the missing of the deceased to PW5 Gopal Jerai, who happened to be the brother-in-law of PW1, so also to the village Chowkidar, bracket PW9, and co-villager Sudarshan Pakharai, bracket PW6. All of them proceeded to the house of the Sarpanch, bracket PW2, and disclosed before him about the missing of the deceased. Then all of them came near the house of the appellants, and PW2 asked the appellants about the deceased, and appellant number 1, Rupa Jerai, if you see data confessed before them that on 25/9/99 night they killed the deceased by throttling and threw the dead body in the
Water of the
water of river Jalapai. On getting such information, the informant and others searched in the river water Jalapai, but they could not trace out the dead body of the deceased. Then PW1 came along with others to the police station and reported the matter. On the basis of the first information report lodged by PW1 on a key police station, Badampahad PS case number 25 dated 26/9/99 was registered under section 302/34 of the Indian Penal Code against all the appellants. By PW15, the OIC of the police station. PW15 himself took up investigation of the case, visited the spot, searched for the accused persons, arrested them, and seized the wearing apparels of the accused persons as per seizure list exhibit 4. The appellant Rupa Jerai, while in police custody, confessed his guilt in presence of the witnesses and led the police and the witnesses to a place where he concealed a cautery and gave recovery of the same, which was seized under seizure list exhibit 2. PW15, the IO held inquest over the dead body of the deceased on 27/9/99 and by combining the head and the body and prepared the inquest report exhibit 3. To also exhibit 10.
Independently as well as by joining.
Independently, the head and the body, and then by joining combinedly. So, and he sent the dead body for post-mortem examination to SD Hospital, Rairangpur. He examined the witnesses, sent the accused persons to the medical officer for collection of the nail clippings and sample blood, and seized the same as per seizure list exhibit 5, and then forwarded the accused persons to the court. He also sent the seized cautery to the medical officer of Rairangpur SD Hospital for examination and opinion, and he also seized the sample blood collected by the doctor of the deceased, collected by the doctor, which was produced by the escort party under seizure list exhibit 12. And on 17/1/2000, he sent the material objects to the DSFL, District so and so, Rasul, no, State FSL, Rasulgarh, through SDGM, Rairangpur, for chemical examination, and on 24/1/2000, on completion of investigation, he submitted charge sheet against the accused persons under section 302(201) by 34 of the Indian Penal Code. Stop. After submission of charge sheet, the case was committed to the Court of Session, where the accused persons were charged under the aforesaid offences since they pleaded not guilty and claimed to be tried. Accordingly, the sessions trial procedure was resorted to establish their guilt. In order to prove its case, the prosecution examined 15 witnesses, PW1 from the Q. The prosecution also exhibited 12 documents, like 11. The defense plea of the appellants was one of denial. Stop. The London trial court, after assessing the oral as well as documentary evidence on record, came to hold that there is no direct evidence in the case, and it's a case based on circumstantial evidence, and the case mainly based on extrajudicial confession of the accused persons before PW 1, 2, 7, 8, and 9. The London trial court, after assessing the evidence of these witnesses, came to hold that the evidence of these witnesses relating to the extrajudicial confession appears to be true, and the confessional statement which is stated to have been made before the aforesaid witnesses appears to be true, free and voluntary one, and it is the consistent evidence of these prosecution witnesses that the accused persons confessed before them that they had killed the deceased. London trial court also placed reliance on the leading to discovery of the weapon of offense, that is Kotari, which was seized by the IO at the instance of the appellant number 1, Rupa Jarai, and came to hold that on account of since the deceased was challenged regarding the practicing of witchcraft for death of the child of the appellant number 2, Bharat Jorai, for which all the accused persons assaulted her, and in furtherance of their common intention, they killed the deceased and took the deceased from her house to the river side and severed her head and body by means of MO1. It was further held that though there are some minor discrepancies in the evidence of the witnesses, but that is not fatal to the prosecution. Accordingly, the London trial court came to conclude that there was a quarrel between the deceased and the accused persons before the occurrence, and they also confessed their guilt, and the appellant number 1 gave recovery of MO1, and from this evidence it is apparent that all the accused persons in furtherance of their common intention had killed the deceased by means of MO1, and found the appellants guilty under section 302(201) by 34 of the Indian Penal Code. From the documents filed, it appears that the appellant number 1, Rupa Jarai, has been released prematurely, and therefore this appeal, we are confining this appeal to the rest 3 appellant, that is appellant number 2, Bharat alias Krishna Jarai, Ghasiram Jarai, and Jagamohan alias Tasu Jarai. Mr. S.D. Das, and senior advocate appearing for the appellants, submitted that it's a case based on circumstantial evidence, and the circumstantial and the evidence available on record do not form a complete chain, and the London trial court has erroneously held the appellants guilty of the offence charged. It further submits that the extrajudicial confession is not at all believable, and it appears from the evidence of PW2 that it is not a voluntary one, and the London trial court should not have placed reliance on such confession. The Land Council further argued that even though in the first information report it is stated that it was only appellant number 1, Rupa Jarai, who has made the extrajudicial confession, but during trial the witnesses have stated that all the appellants have made extrajudicial confession. It is further argued that though in the extrajudicial confession it is stated that the deceased was throttled death and thereafter threw in the river water, but the post-mortem report shows that some penetrating wounds were found on the body of the deceased, and the head was removed, decapitated, and therefore the extrajudicial confession runs contrary to the medical evidence. And even though at the instance of the appellant number 1, the cautery was recovered, but on chemical examination it was found there was no blood on the cautery, and therefore this recovery of the cautery cannot have any link with the offense in question, and the since the circumstances available on record do not form a complete chain from which it can be said that it was only the appellants who are the authors of the crime, it's a fit case where benefit of doubt should be extended in favor of the appellants. The Mr. Aurobindo Mohanty and an additional standing counsel, on the other hand, supported the impugned judgment and argued that since the minor child, minor daughter of appellant number 2 died and the appellants were suspecting that it was the death took place on account of the witchcraft of the deceased and also assaulted the deceased, the same can be said to be the motive behind the commission of offense. It is further argued that even though there is no direct evidence, but the extrajudicial confession of the appellants before the witnesses corroborate each other, and since the medical evidence also supports that it is a case of homicidal death, and the weapon of offense was recovered at the instance of the appellant number 1. The Land Trial Court has rightly placed reliance on this evidence to hold the appellants guilty, and therefore the appeal should be dismissed. Adverting to the contention raised by the Land Counsel for the respective parties, let us first examine the evidence on record to see whether the prosecution has successfully established that the deceased has died a homicidal death or not. In view of, in this context, the evidence of the doctor, bracket PW, is a doctor PW 14. PW 14 is very relevant. PW 14 was attached to SD Hospital, Raidongpur, who conducted post-mortem examination on 28/9/99 over the dead body of the deceased and found so and so. That he also examined the weapon, that is the cautery, which was produced by the investigating officer and answered to the query that the injuries sustained by the deceased were possible by MO1. The Land Counsel for the appellants has not challenged the finding arrived at by the Law and Trial Court regarding the homicide of the deceased. Therefore, we are of the view that it has been proved that deceased died a homicidal death. In the case in hand, admittedly, there is no direct evidence, and the case is based on circumstantial evidence. The law relating to the circumstantial evidence, basing conviction on the circumstantial evidence, is clear in view of the off-quoted decision in Sarab Rishan Sadhan, 84 Supreme Court should have quote Karlam. In the case in hand, as rightly stated in the impugned judgment, that the case based on mainly on the extrajudicial confession made by the appellants before the witnesses. It is apparent that from the first information report, it appears that after the extrajudicial confession was made the first information report was lodged by PW1. However, in the first information report, there is no mention that all the appellants made extrajudicial confession. Rather, it is very clear from the first information report that it was only the appellant number 1, Rupa Jerai, who made such confession. Though during trial, the witnesses have stated that all the appellants have made extrajudicial confession, but the previous statement of the witnesses have been confronted to those witnesses, and it has been proved through the investigating officer bracket Ray PW15 that they have stated in their previous statement that it was only appellant number 1 who made extrajudicial confession. The witnesses have stated that when at the first instance the appellants were asked about the death of the deceased and about the whereabouts of the deceased, they denied, and they denied about their also involvement, and then the accused persons were again called and asked about the death of the deceased, and then the so-called the said extrajudicial confession is stated to have been made. In this context, the evidence of PW2, the Sarpanch, is very relevant, before whom all the witnesses have stated that the extrajudicial confession was made. PW2 has stated that on 25/9/99, PW1 and PW7 came to his house and they told that they couldn't get the deceased after search. And PW9, the village chowkidar also told him that he searched for the deceased but could not get her. PW2 further stated that thereafter he himself, along with PW1, PW7, PW9, went to the house of the deceased but could not locate her. And when he came to know that the accused persons assaulted the deceased on the previous day, they called the accused persons through village chowkidar bracket PW9. PW2 further stated that on his question to the accused persons denied by saying that they had not assaulted the deceased nor killed her. PW2 further stated that after some time the accused persons told him that they had killed the deceased, and further stated on his query that they had thrown the deceased in the river. In the cross-examination, PW2 has stated that at first the accused persons denied about the death of the deceased. And when he asked them twice, they also denied about the whereabouts of the deceased. He further stated that when he told the accused persons that if the matter would be reported, then the matter would be complicated, and further told the accused persons that he could subside the matter in the village about the assault on the deceased if the deceased would be available. And then the extrajudicial confession is stated to have been made. The evidence of PW2, which has been elicited in the cross-examination, clearly indicates that not only when the accused persons were told about the matter to be reported before the police and that it would be subsided in the village, the so-called confession has been made. And therefore, it cannot be said that the accused persons, the confession was voluntarily made before PW2 and others. At this juncture, we found that the statements of the witnesses, including PW2, that all the accused persons made extrajudicial confession, and thereafter PW1 went to the police station to lodge the FIR. But in the first information report, it is stated that only only the appellant one, Rupa Jerai, has made the extrajudicial confession. And whatever has been brought out by confronting the previous statements and proved through the IO, it also indicates that it was the appellant number one who had stated about made the extrajudicial confession. Therefore, the Lennon trial court has aided in observing that the accused persons voluntarily came to the house of the PW2 and made the extrajudicial confession. Though the contention was raised by the Lennon Defense Counsel that in the circumstances in which the confession was made by the appellant number one, it cannot be said to be voluntary in nature, but the Lennon trial court has not given any importance to the same and erroneously held that the confession is true, free, and voluntary one. In the factual scenario, we are of the view that since it was only the confession of the appellant number one and not by the other appellants, and it appears that it was not a voluntary one, no reliance can be placed on such extrajudicial confession, and it is not admissible in the eye of law. The extrajudicial confession, as stated in the first information report, is that the appellant was, the deceased was throttled to death and thereafter threw in the river water. When the dead body was recovered, in decapitated body, the injuries, the penetrating wounds were noticed on the person of the deceased, and the doctor has stated very categorically that the cause of death was due to capitation of the head and probably by sharp cutting weapon. Therefore, we are of the view, as rightly pointed out by the Land Counsel for the appellant, that the manner in which the death is stated to have been caused in the extrajudicial confession runs contrary to the death as has been found by the Dr. PW14. The evidence relating to the recovery of the weapon of offense, that is Katari, at the instance of appellant number 1 is consent. Since in view of the chemical examination report, which has been marked as exhibit such and such, no blood was detected in the Katari, merely because the doctor has stated, Dr. Bracket Alexander, PW14, has stated that the injury sustained by the deceased would be possible by such Katari. We are of the view that this circumstance alone is not sufficient to hold the appellants guilty. There is no evidence on record, clinching evidence on record, that the appellants committed the murder of the deceased, and after committing the murder, they caused disappearance of the evidence by throwing the dead body into the river water. The so-called extrajudicial confession, as we have already discussed, is not admissible since it is not voluntary one. In view of the following discussions, we are of the view that the circumstances available on record do not form a complete chain so as to come to a irresistible finding that it was the appellants who are the authors of the crime, and therefore the impugned judgment and order of conviction of the appellants under section 302(201)(34) of the Indian Penal Code not sustainable in the eye of law, and accordingly the same is hereby set aside. The appellants are acquitted of the charges. The criminal appeal is allowed. They are on bail. The bail bond stands cancelled and the COP bonds discharged.
Pardon me, Your Lordship. Pardon me to make a mention.
More. Make
My lord, item 21 to 25. In pass over, I obtained instruction in item number 22.
ଗୋଟେ କହୁନାହାନ୍ତି 21 ଟା କଣ
21 ର instruction ଟା ଆସିଲା ଟିକେ next week ଆସୁ
21 ଟା next week କହୁଛି।
ନାଇଁ 21 22
21 22 next week କହୁଛି।
next week
21 22 lagi council for the state to take some further time to obtain instruction regarding compliance of the order to use.
But 23 is concerned, received instruction that the husband of the present petitioner, he filed application under section 18(1) of the LA Act. That before the civil court senior division Nuapada, that case number registered as LAR number 23 of 2009, and the said case was disposed of on 25/3/2013 due to non-prosecution. Therefore, the present petitioner, he filed a CMA 7 of 2019. that is pending. The present status of that case as called for. Again, the 28 area.
What was the order passed? What order we passed? So and so.
This is 23.
23 though.
My lord.
23, according to Mr. Behra, the petition is aggrieved by the non-disposal of the application filed under 28 of
Yes.
so and so. So what we passed, the considering the submission made and without this petition is disposed of, directing the opposite party number 3 to dispose of the LA case number so and so in accordance with law within a period of 3 months from the date of production of the certified copy. And it is directed in case the application of the petition is allowed, then and there is no legal impediment, compensation amount. To कौन है ला?
सेते कहउछन से 18-1 रो केस टा फाइल करथिले सेटा नॉन प्रोसिक्यूशन डिसमिस हे गेला रिस्टोरेशन टा फाइल हिची रिस्टोरेशन रा कोन स्टेटस अछि गवर्नमेंट प्लीडर को मगा हिची तार सर्टिफिकेट कॉपी ता न आसला पर्यंत एटा से डिस्पोज कर पानी
माने इट डिपेंड्स अपॉन द डिस्पोजल द रेफरल केस.
यस. सेम खाता सेम प्लॉट ऊपर 28 रे
यो खाली लिखछन जो डिस्पोज ऑफ बेली अपन लिखिना दी कि जो कौन कोजन डिसमिस फॉर डिफॉल्ट ना कौन कोजन
हां एनल सीएमए काई फाइल था
सीएमए फाइल छ सही केस रे सीएमए फाइल
सही केस अराइजिंग आउट ऑफ एलआर केस नंबर 23 ऑफ 2009.
So what do you propose?
We propose 6 month time to comply the order. Requested to.
That means this order is subject to the disposal of that LA referral case. उसने जो डिसमिस ହେଇଥିଲା ये बोधे क्लेम करछंती से भीतर.
हां हस्बैंड फाइल करला डिसमिस ହେଇଛି.
As per judgment dated 8/5/2023 in respect of LAR case number 30 of 2017. अच्छा, basing on that this claim was made.
अपन इंस्ट्रक्शन नेबे ना रखी दबा
इंस्ट्रक्शन नेबे बस
हम दियो तो सिंह
कॉपी दे दे
और डेट रा बुझी दियो तो करेक्ट सिचुएशन कोन एरा ठीक से रिफ्लेक्ट ही छी नहीं लेट ऑन दिस the Land and Council for the state has produced the written instruction dated 20/10/2025 from Special LA and RRO Lower Indra Irrigation Project Kharia, which indicates as follows: that in pursuance to suitable further which is taken off, why a case has not been taken. A copy of the said later has been handed over to Mr. Behra to seek some time to obtain instruction. That was 2 सप्ताह पर रखु और सेटा श्री समन सिंह हमरो 18 तारीख मंगलवार कि गुरुवार दिन तो देखि रखो এই 18 तारीख की 20 तारीख में 2 सप्ताह दिए थी
ये लॉर्डशिप
स्टेटमेंट
this the application the 28 application related to LR case number 30 of 2017 से जो इंस्ट्रक्शन दउचंदी LR case number 23 of 2009
तो सेटा इंस्ट्रक्शन को गोटे
23 of 2009 रे लिखुचंदी हमर को
सेटा को बुझी के दियो तो क्योंकि
हमर क्लेम अछि 28 एप्लीकेशन अछि LR के रिलेटिंग टू रेफरेंस केस नंबर 30 of 2017
जोटा डिस्पोज फेच अपन दैचंदी
आगे एटा सीए कोन दउचंदी LR केस नंबर 23 of 2009 दिस इज नॉट रिलेटेड टू द
आसु.
अच्छा देखिए
इंस्ट्रक्शन में
आपण ए रीड पिटिशन देखि बाहर करो
मुदैची मु तादरे हम कंटेंट रे भी अनेक्सर करछि हम एप्लीकेशन 28 एप्लीकेशन रनिंग पेज 12 बे लॉट्स
that is there in paragraph
1 रो अछि.
judgment dated 8/5/23 in respect of LAR 30 of 2017.
2017
8 कितने नंबर पूछते हैं
ଇଏ ଦଉଛନ୍ତି
ନା, ନା, ଆପଣ-
LR case number 23 of 2019.
23 of 2009
Nine.
ଆପଣ ଫାଇଲ କରିଥିଲେ 23 of 2009 husband of the petitioner namely ଲୋଚନ ବାଗ
ସେ ତା ପୂର୍ବରୁ ଗୋଟେ ଫାଇଲ କରିଛି ନା
File
କଣ?
କରିଥିବେ ଆଉ।
LR 30ଟା ହଉଛି ରେଫରେନ୍ସ ସେଟା 30ଟା ଡିସ୍ପୋଜ ଅଫ ହେଇଛି
ସେଟା
ତା ଅନୁସାରେ
ଏଇଟା
28
ଟିକେ
ଏଟା
କରିଥିଲେ ସେ।
28 ଏଟା କନସିଡର ହବ ବୋଲି ବର୍ତ୍ତମାନ ତାଙ୍କ ପ୍ରେୟାର କିନ୍ତୁ ହଜବେଣ୍ଡ ଅଫ ଦି ପିଟିସନର ଲୋଚନ ବାଗ he filed an application under section 18(1) of the LA Act
Oh.
which were referred to the civil court senior division Nuapada
That was dismissed.
numbered as LR case number 23 of 2009 that was dismissed on 25/3/2013. Again, the present petitioner, who is the wife of the Lochan Bag, he filed a miscase for restoration.
Oh, CMA, अच्छा।
ଆଚ୍ଛା ଏଇ ଯୋଉ ଲୋଚନ ବାଗ ଲେଖା ହେଇଛି ଲୋଚନ ବାଗ ରେ ବ୍ରାକେଟ ରେ ଲେଖି ଦିଅନ୍ତୁ ହଜବେଣ୍ଡ ଅଫ ଦି ପିଟିସନ ହେଲେ ଜଣା ସବୁ ଏଇଟା ଗୋଟେ ଅନ୍ୟ ନା ଆସିବ ଆଉ ବାକି ସବୁ ଥାଉ ପୁଣି ଇନଷ୍ଟ୍ରକ୍ସନ ନିଅନ୍ତୁ ଇଏ ଗଲା ଆଇଟମ ନମ୍ବର 23 ଗଲା ତାପରେ
24 instruction already 28 application disposed of
ଏଇଟା
for release of the decretal amount. It was referred to the whatever.
instruction that quote for this content petition is closed. Next.
Next also disposed of.
This one, the it have closed for the Next, ଆଉ କଣ ଅଛି? ଅଛି? ହଁ ପାଠ ଗୋଟେ ଆଉ କିଛି ମାସକୁ ନାହିଁ ତ କୋଉଟା ଆଇଟମ ନମ୍ବର ସେଗୁଡ଼ା ଡାକୁନ ଆଇଟମ ନମ୍ବର 3ଟା କଣ ପାଇଁ ପାସ ଓ ଆକୁ ପୁରା କହିବା ପାଇଁ ଇଏ ମିଷ୍ଟର ମହାରାଜକୁ ପୁରା କହିବାର ଥିଲା କଣ ହେଲା ଆଇଟମ ନମ୍ବର 3 କ୍ରିମିନାଲ ଅପିଲ ଆପଣ କହିଥିଲେ ଯେ ମିଷ୍ଟର ମହାରାଜକୁ ଖବର ଦେବେ ବୋଲି ପାର୍ଟ ଅଫ ଦି ଅର୍ଡର ଡକା ହେଇଛି ଆଉ ଗୋଟେ ଆଉ କୋଉଟା କୋଉଟା ସେଗୁଡ଼ା ନୁହେଁ ମାନେ ଯୋଉଟା ଲଞ୍ଚ ପରେ ନବାର ଆମର ଥିଲା ଏଇଟା ତ ଡିସ୍ପୋଜ ଅଫ୍ ହେଇଗଲା ରୂପା ଜରାଇ ଏଇଟା ଅଲାଉଡ ହେଲା Okay, now we come to when actually ଖାଲି matter କରୁଛି କଣ ହେଲା କୁହନ୍ତୁ ହଁ ରିଟିନ ନୋଟ ଆପଣ ଦେଇ ଦେଇଛନ୍ତି ନା କଣ
ମୁଁ ସାଇଟେସନ
ହଁ ସାଇଟେସନ ଟା ଦେଇ ଦେଇଛନ୍ତି ଆଉ ଆମେ ଲାଷ୍ଟ ଟାଇମ ପୁରା ଗୋଟେ ଅର୍ଡର ଲେଖା ହେଇଥିଲା ଯେ ଆଉ ଯାହା ଦବା କଥା କାରଣ ହିୟରିଂ ତ କ୍ଲୋଜ ହେଇଯାଇଥିଲା ନା
ମାନେ ଏଠି ଆଉ ଟିକେ ମାନେ ଆଉ ଟିକେ କ୍ଲାରିଫିକେସନ ଭିତରେ ଅଛି
ନାଇଁ ଏଇଟା ଆମେ ରୁହନ୍ତୁ ଏଇଟା ମିଷ୍ଟର ହ୍ୱାଟ ଇଜ ମିଷ୍ଟର ନାୟକ
ମୁଁ ସେ ଯାଇକି ଫୋନ କଲା
ଏଇଟା ସେଇ ଯୋଉ ସାଙ୍ଗରେ 2 ଜଣ ଯାଇଥିଲେ 4 ଆଉ 8 ସେ ଯୋଉ ଜଣେ କଣ 2 ଦିନ ପରେ ଇଏ କଲା ସେଇଗୁଟା ସେଇ
ରାଉରକେଲା ଭୁବନେଶ୍ୱର ପଳେଇଥିଲେ
ହଁ ନାଇଁ କଣ ହେଲା ଆପଣଙ୍କର ଆଉ କିଛି ଆପଣ ରିଟିନ ନୋଟ ଅଫ ଦେବେନି ତ ନାଇଁ ନାଇଁ ଆରେ
କହିଥିଲେ ଗୁରୁବାର ବୋଲି ମୁଁ ମଧ୍ୟ
ଆପଣ
ଆକ୍ଚୁଆଲି ଆଜି ରହିବିନି ବୋଲି ସେଦିନ କହୁଥିଲି ଯେହେତୁ ବର୍ଷା ପାଇଁ କ୍ୟାନସେଲ ହେଲା ଆଉ ରିଟିନ ନୋଟ କରିଦେବି
I think you have both of you have argued for 2 days.
Yes.
ମୁଁ ଆଜି ଆମର ଥିଲା ଯେ ଆପଣ ଦେଲେ ଆମେ କ୍ଲୋଜ କରିବୁ ବୋଲି
ଲାଷ୍ଟ ଡେଟରେ ମିଷ୍ଟର ରାୟଗୁରୁ ରିକ୍ୱେଷ୍ଟେଡ ଟୁ ପୋଷ୍ଟ ମାନେ ଫର ଆର୍ଜେଣ୍ଟ ମ୍ୟାଟର
ରହିବି ନା ନଥିଲା
କହିଥିଲେ
ଓହୋ
ମୁଁ
30 ତାରିଖ ଦିନ
ହଁ
ଓ ହେଲା ଠିକ ଅଛି 30 ତାରିଖ ଦିନ
ଆଉ ଟିକେ ଖାଲି ସମ୍ମିଶନରେ କରିଦେବ
ନାଇଁ ଆପଣ ଯାହା ଦବା କଥା ଏକାଥରେ ଦେଇ 30 ତାରିଖ ଦିନ କ୍ଲୋଜ କରିବେ
ଖାଲି
ନା ସେଇଦିନ ତ ସବମିଶନ କରିବ ସେଇଦିନ
ଆରେ 30 ତାରିଖ ଦିନ ଆପଣ ରିଟିନ ନୋଟ ଯାହା ଦବା କଥା ଦେବେ ଆଉ ଯାହା ଫାଇନାଲ ସବମିଶନ କରିବା କଥା କରିଦେବେ ଆମେ କ୍ଲୋଜ କରିଦେବେ तो कथा हो पुणी आज टिके पुणी सेदिन टिके ହେଲା
My lord, Mr. Maharaja is now at Bhubaneswar. He told that last date it was stated to taken up 1 week after. Therefore, he has.
No, now the appellant is alive. If he is to argue the matter, there is no problem. The case has to be, it will automatically come.
गुरुवार हेले मधे से करपरिबे।
हाँ नहीं हमें जानिବାକୁ ଚାହୁଁଥିଲି ଯେ पेपर बुक रिसीव करछन
ना
ना
करना है।
हां पेपर बुक ହେଇନି यो भूल ले लिखी ना ना प्रकृति रे
ना सीएफई रिसीव करना है।
ना रिसीव करना तो कहते हेई जाई निश्चित
ଏଟା 2004 नो
କନସିଷ୍ଟେଣ୍ଟଲି ସବୁ
पेपर बुकटा केन 2004 मसरा अपील ଯେତେକ ମ୍ୟାଟର ଲିଷ୍ଟ ଆଜି ହେଇଛି ସବୁ ଗୁଡାକରେ ତ ପେପର ବୁକ୍ ହେଇଛି ଆଉ ଏଇଟାରେ କଣ ପାଇଁ ହେଇନି ୟା ଡିଲିଂ ଆସିଷ୍ଟାଣ୍ଟ ଏଇଟା ଫଲ୍ଟ ନା ଦୁଇ ହଜାର ଚାରି ମସିହାର କେସ୍ ଆଡମିଟ ହେଇକିନି ଇଏ ହେଲା
by the time the matter is ready, let them prepare it. Because ये ହେଇଗଲାଣି
ସ୍କାନିଂ ହେଇକିନା କଣ
କଟ କରିକି ଆଉ ସମୟ
ଏ
ଲାଗିବ
ଏ ଆଇଟମଟାକୁ ଡିକ୍ରେସନ ନେଇଥିଲେ କିଏ ଫାଷ୍ଟ ଆୱାର ଥିଲେ ଆଇ ଥିଙ୍କ ପ୍ରଭାକର ନେଇଥିଲେ ବୋଧେ ଆଉ ତାପରେ ଏଇଟା ଯୋଉ ସବମିଶନ ଏଇଟା କରି ତାକୁ ମିଶେଇ ଦେବେ ହେଲା the Learning Council for the State contacted Mr. P.K. Maharaj, who submitted that he will argue the matter. However, it is found that the paper book has not been prepared. Immediately, steps shall be taken for preparation of the paper book since this is a criminal appeal of the year 2004. The matter will be listed on 6th of November 2025. ଆଉ କୋଉଥିରେ ପେପର ବୁକ୍ ହେଇନି କି ଦେଖିଲେ ଯେ ପୁରୁଣା ମ୍ୟାଟର ସବୁ ଅଳ୍ପ ସବୁ ହେଇଯାଇଛି ସବୁ ହେଇଯାଇଛି नो इवन जोड़ा हियरिंग पे लिस्ट है जी सब अच्छे आप कौन फोन तो मिस्टर नायक आपका फोन तो किया छंदी
कितने
31. I'm sorry.
yes
Item 31, I beg your lordship's apology. The last occasion I was absent because of confusion of names, because the other names were also there. Myself, Services Minister, appearing on behalf of the appellant, number 1, and appellant number 2, a report has been called for by your honor, and it has been found that appellant number 2, Akshay Kumar Naik, has died and the appeal stand abated.
So now this appeal is only with respect to appellant number 1,
Yes,
Akshay Kumar Naik.
yes
So what is your good name, Learning Council?
The last occasion I did
No,
not
what's your
appear
good
when the
name?
matter was
ଆପଣ
called.
ନାଁ କଣ
ସବ୍ୟସାଚୀ ମିଶ୍ର
ଅଛି ତ
your name
ଏବେ ଅଛି ଆଗରୁ ସେଟା ମିଶିକି ନାଁଟା ଥିଲା
ମିସିଂ ମାନେ
ଅଲଗା ପ୍ରିଭିୟସ୍ ଆଡଭୋକେଟଙ୍କ ନାଁ ସହିତ ମିଶିକି ଥିଲା ସୋ ଆଇ ୱାଜ କନଫ୍ୟୁଜ କାରଣ ସେତେବେଳେ ଦିଆ ହଉଥିଲା ପୁଣି ଅଲଗା ଲୋକ ଜେଲରୁ ସେତେବେଳେ ପିଟିସନ ପକେଇବୁ ତ ସେଇଟା କନଫ୍ୟୁଜନ ଥିଲା ଏଥରକ କିନ୍ତୁ ଆପଣଙ୍କ ଅର୍ଡର ଫଳରେ ଖାଲି ମୋ ନାଁଟା ଅଛି
ହଁ
ନା ଆଜି ରେଡି ଅଛନ୍ତି ତ କରନ୍ତୁ।
ହଁ ଷ୍ଟାର୍ଟ
ଦିଅନ୍ତୁ
if your lordship permits then I
permit ଆଉ କଣ ଆପଣ have you not have we engaged you or
yes
who order dated
ଆମେ
बाईस
ନିଜର 22
the High Court
ମସିହାରେ
Legal Services has engaged Mr. Sarvesachi Mishra. So you have been engaged. So what is the question of permission ଆଉ କଣ?
ନାଇଁ ପରମିଶନ କିଛି ନାହିଁ ମାନେ ପ୍ଲିଡ କରିବାକୁ ଚାହୁଁଛୁ ଯଦି
ହଁ
23/9/2025 से दिल्ली Mr. Sabyasachi Mishra, Planet Council has been intimated regarding listing of the case
ହଁ
through the contact details provided by this OHSCLC. Soft
ठीक
copy
ଅଛି
of TCR is available.
ଦିଅନ୍ତୁ ये कौन है वो? तो वो ये फ्री चाहिए तो मशीन ने पर जो लवली के 5-6 घंटे रहती तो कौन हुआ हाँ
PW1 and PW2
PW1 and 2 are PW1 is the injured witness. Both are injured witness.
no PW1 is the injured witness and PW
पढ़ो PW आगे एटा पढ़ो
नहीं please माननीय श्रीयुक्त ऑफिसर इंचार्ज पुलिस स्टेशन चौद्वार महाशय निवेदन अभिप्राय कि जे मु शैलेंद्र मल्लिक
PW9
पिता पूर्णचंद्र मल्लिक आगे
नहीं स्लो शैलेंद्र मल्लिक PW9
कि जे मु शैलेंद्र मल्लिक पिता पूर्णचंद्र मल्लिक सा कपालेश्वर नुआसाई निवेदन अभिप्राय एक जे राति 11 घटिका समय मोर सान भाई रवीन मल्लिक ठारू खबर पाइली जे मोर अन्य जने भाई फकीर मल्लिक तार सांगरे 2 जन सुखरंजन और अमल को सहित आसुतला बेले रास्ता रे आड़ीसाई निकट रे अभय और तार भाई अक्षय पिता नकुल नायक 2 जन ठेंगारे बाड़े रास्ता पर पकाइछन्ति ताठारू खबर पाई मु आसी ताकू सेठारे रक्ताक्त अवस्था देखि मेडिकल को पठाई देछि एणु विनुत अनुरोध होई विधिवत तदंत कराଯାଉ उपयुक्त व्यवस्था करी आंब मानकर जीवन निरापत्तार व्यवस्था कराଯାଉ
so who is alive now अक्षय
अक्षय has died your lordship
Abhay is
appellant number 1 is and is scribed by Rajat Kumar
अक्षय कुमार नायक is alive ना
alive yes.
he is appellant number
1 this has been scribed by Rajat Kumar Ponda
so who are the eyewitnesses
eyewitness my lord Sukharanjan
नहीं नहीं
PW1 Sukharanjan and PW2 Amal PW2 Amal
Amal Das
who is the doctor
is PW8
postmortem
PW4 is the doctor who treated PW1
this informant is PW
9
What is the name of the deceased?
Fakir Malik.
Fakir Malik.
The deceased was coming with PW1 and PW2.
Yes.
କୋଉଥିରେ ଆସିଥିଲେ?
ସାଇକେଲରେ।
ହାଟ ସାହି ନିକଟରେ ଅଭୟ ଓ ତାର ଭାଇ ଅକ୍ଷୟ ଏମାନେ ଠେଙ୍ଗାରେ
ହାଡି ସାହି ନିକଟରେ
ହାଡି ସାହି
ଅଭୟ ତା ଭାଇ ଅକ୍ଷୟ ଦୁଇ ଜଣ ଠେଙ୍ଗାରେ ବାଡି ରାସ୍ତା ଉପରେ ପକେଇ ଦେଇଥିଲେ।
So these are the so let us place that PW1 the evidence to the vessel also.
PW1 Sukharanjan Mirtha. The accused person belongs to Hadisai of Kopleswara Nuasahi. I know the deceased, who is also man of Nuasahi. We used to net fish, net fish along with me. The occurrence took place on 28/1/1998. There was a program to net fish and with the deceased and Amal. They had come to Bajar to take betel, pan and bidi and etc. It was being a chilly weather. I told them to cancel the program to go fishing. So I, along with other persons, returned back from Bajar and proceeding to our Sahi. On the way to our Sahi near the Hadisai Chakka, the accused persons came and started rebuking. I intervened and there was exchange of word. From the spot, accused Abhay went away and called the other accused his brother, and both of them came with bamboo lathi. They were trying to assault Akshay. I intervened. So Abhay and his brother went a little ahead. So I thought they will not create any trouble. When I was standing by, Akshay dealt a lathi blow on the back of my head, as a result of which I sustained injury and fell down. Thereafter, Abhay and his brother again Thereafter, Abhay and his brother again assaulted me by a lathi prior to assault me, but the blow did not hit me. Did not hit me, and the lathi struck the ground since I was lying in the ground. Both the accused started assaulted with lathi to Fakir.
The deceased.
At the relevant point of timing, Amal was already fall on the ground since the accused persons had posed three cycles upon him. After assaulting the accused persons fled away. Fakir was unconscious, causing bleeding injuries in his person. Amal Das went to inform the house of Fakir. So Robin, Soilon and others came. Then both of us were taken to private hospital at Chaudhar in a rickshaw. That private nursing home is Anwar Khan Private Medical, but they advised to take to Cuttack immediately after I was given treatment. But by seeing the condition of Fakir, they advised to take him to SCB MCH. Cuttack, both of they taken to SCB MCH in a car. In the early morning, Fakir died.
PW1 is an injured eyewitness. So for him also the charge has been, for his assault, the charge has been framed 307. And both the appellants were also found guilty under such offense. 307.
307 ne khali Akshay has been sentenced.
Okay. So who is that doctor who was examining that PW1?
Bhuvananda Marana, PW4, Your Lordship.
So the injured witness version in chief is that not only he was assaulted by Akhya
And Abhay.
and Abhay, but Abhay not which.
ଅଭୟ ପେଜ 40 ର ଫାର୍ଷ୍ଟ ଲାଇନ୍
Might is. ତାପରେ both of them ସେ କହୁଛି
Assaulted
both the
Fakir.
accused assaulted Fakir. Then Fakir sustained injury and
fall on the ground.
fell on the ground. Then he was shifted to Cuttack.
Nearby hospital and then to SCB, where he succumbed to death in the next day morning.
ରାତିରେ ଘଟଣା ହେଇଛି ତାପର ଆର୍ଲି ମର୍ଣ୍ଣିଂ ରେ ଡେଥ୍ ହେଇଛି.
Okay, now you come to the cross-examination. Let us see.
Cross-examination by the judge. I cannot say the English calendar months. I have also no idea about English calendar date. The occurrence took place about 1 year back. The route in which we are going in is the only route of our Sahi. When we reached the chalk, we saw Biranchi, Kuntia, and Basanta were quarreling with the accused persons. Many people of Adisai had also assembled there. Prior to our arrival, they were quarreling with each other. Fakir Malik, under arrival, went there and asked as to why quarreling. When he questioned, there was Patitundo. It was not a fact that I have stated before the police that after reaching Sweeper Colony Chaka, we saw Kulia and Biranchi of our Sahi, and Biranchi and Fakir Malik had exchanged words in the chalk. When Abhay Naik came, the appellant number 1 came and intervened and asked Fakir as to why quarreling. Fakir shouted at his tu kiebe third person and gave 2 push, dui dhokka. When Abhay and Fakir quarreled, I remained there all along. That quarrel took place between them for 10 to 15 minutes. I had separated them. After I separated, people of Harijana Sahi were still there, and we also remained there. At that time of incident took place, except the accused, no other Harijana Sahi people had come to the spot. Then further cross-examination after launch, Fakir had told the accused, Hadi toka tu kahinki baka baka karuchu. After sustaining injury, I had not lost at all my sense and I had conscious. About half an hour of assaulted, we were taken to hospital. At the time of incident, only Amol was there near the spot, falling on the ground, and no other villagers present there. In the private medical, the son of the Anwar Khan applied bandage to me, but the deceased was not treated for his injuries. It is not a fact that people of Hadisai also used to make fees, and there was quarrel between Hadisai and ourselves and dispute of making fees. It is not a fact that we had initiated the quarrel and rebuked to the accused and other and provoked them by abusing filthy words. It is not a fact that accused persons have not at all assaulted, and I am deposing falsely to the dispute.
So as it appears, there was a quarrel and some comments were also passed by the deceased.
Yes.
Mr. Naik,
Yes.
କଣ ହାଡି ଟୋକା କରିବା କହିଛନ୍ତି ସେ ଏବଂ that was prior to the assault. ଗୋଟେ ବ୍ଲୋ ରହିଛି ହେଡ୍ ରେ ଯୋଉଟା କି ଡେଥ୍ ଅଛି ମାନେ ଇଏ କରି ବାକି ସବୁ ନନ୍ ଭାଇଟାଲ ପାର୍ଟ ଅଫ୍ ଦି ବଡିରେ ଆବ୍ରେଜନ୍ସ ଗୁଡାକ ରହିଛି abrasion confusion. Left knee, left thumb, left wrist, elbow joint, forearm. So corresponding external injury number 1 is in the left temporal region, so and so. which is due to craniocerebral injury. What is the defense plea? Total denial or anything?
Defense plea was total denial, but the PW1s and PW2s, whose on whose evidence as eyewitness the learned trial court has relied on, both are a little bit contradictory, Your Lordship. May I, if you permit, then I place the PW2.
PW1 ର ଯଦି evidence ଦେଖିବା ଏମାନେ ଆସୁଥିଲା ବେଳେ ପ୍ରଥମେ on the way to our Sahi near Adi Sahi Chowk, the accused persons came and started rebuking. I intervened and there was exchange of words. Again. From the spot, accused Abhay went away and called the other accused his brother, and both of them came with bamboo and lathi. They were trying to assault Akshay, and I intervened. So Abhay and his brother went a little ahead. I thought that they will not
Create any trouble.
create any trouble. When I was standing
Standing by. Akshay dealt.
Akshay dealt a lathi blow on the back of my head, as a result of which I sustained injury, fell down. Then
They assaulted.
he fell down. Next page. The
Thereafter, Abhay
Thereafter, Abhay and his brother again assaulted me by lathi. Prior to the assault to me,
but the lathi blow did not hit me.
me. Lathi struck on the ground since I was lying down. Both assault on PW1 took place fast, as
Both
it
the-
appears. Then both the accused persons assaulted with lathi to Fakir.
Fakir.
That means the deceased at the relevant point of time, Amal Das already
Fall on the ground.
Already fall
all on the ground since the accused persons had. Who is Amal Das?
Amalnath PW2.
Watch out. Three the accused persons had passed three
Three cycles
cycles
upon
of Acha.
upon him.
After assaulting the accused persons straight away, Fakir was unconscious but
causing
Bleeding injury
in his
on his
person.
person.
Amal Das went in from the house of the Swansu. Just came, then both of them were taken to private Swansu, which are then by civil wala. Prior to এইটা দেখিলে যেটা ফার্স্ট প্যারা ক্রস এক্সামিনেশন সেকেন্ড প্যারাগ্রাফ করি prior to our arrival they were quarreling with each other.
Biranchi,
মানে
Biranchi Khatua, who are quarreling? We saw Biranchi Khatua and Basanta were quarreling with accused person. There are
So
many
Biranchi and
Basanta,
they were quarreling with
accused person.
So many people of Hadisai had already
Assembled there.
there. ठीक है जी.
Prior to our arrival.
Prior to our arrival, they were quarreling with each other. Fakir Malik, upon arrival, under arrival, upon arrival went there. He interfered actually. This asked as to why quarreling. When he questioned, so he becomes a peaceful intervener. When he questioned, there was party thunder. It's not a fact that I have stated before the police that after reaching Sweeper colony, we saw Ulia and Biranchi of our Sahi, and Biranchi and Fakir Malik had exchange of words in the chalk, and when Abhay came and intervened, asked Fakir as to why quarreling, Fakir shouted at him to give a third person and gave the
to
Dhaka. When Abhay and Fakir quarreled, I remained there all along. That quarrel took place once. So I had separated them. After I separated, people of Harjan Sahib were still there. We also remained there. At that time, incident took place, except the accused persons who is also. Then Fakir had told the accused, Hadi Toka, tu kahi ki bak koruchu after session. So these are the Ajit. There was no premeditation for assaulting the deceased. The deceased, on the other hand, intervened and tried to subside the dispute. We can, which was subside that quarrel, which was going on between Biranchi and Basanta.
Yes.
ତା ଭିତରେ ଏମାନେ ତାକୁ ଯେତେବେଳେ କହିଛନ୍ତି ସିଏ କହିଲା ତୁ କିଏ ବି ଥାର୍ଡ ପର୍ସନ ଗୋଟେ କହିଲା ଆଉ ଗୋଟେ ତାକୁ କହିଛି
ଧକ୍କା ଦେଇଛି
ହାଡି ଟୋକା ତୁ
କାହିଁକି ବକ ବକ କରୁଛୁ. That is the. So this is the background, and quarrel with the deceased arose because of his intervention, and he also told them some. Then this assault took place, and the PM report indicates that
One injury which is
one
caused-
blow is fatal on the head. The other blows are on the arms, etc.
Yes.
So, କେତେ ବର୍ଷ ରହିଛି?
ରହିଛି ମୁଁ ରେକର୍ଡ ଦେଖୁଥିଲି
ହୁଁ।
ଆରେଷ୍ଟ ହେଇଥିଲା 31/1/98
ଟିକେ ରୁହନ୍ତୁ, ଆମେ ଅଭୟ 31/1
both the accused person.
ନାଇଁ ସେ ଆମର ସେଇ ତାରିଖ ଗଲାଣି କାମ ସେ 31/1/98 ତାପରେ
ହାଇକୋର୍ଟ ରିଲିଜ ହେଇଛି
ନାଇଁ ଆଉ ଟ୍ରାଏଲ କୋର୍ଟରେ ବେଲ୍
ଟ୍ରାଏଲ
ହେଇନି?
କୋର୍ଟଟା ସେଇଟା ଦେଖ
Order sheet of work. Both the accused persons produced. Produced in court now. Trial court रे बेल नहीं, तापरे हाई कोर्ट देखो
21/10/2003 21/10/2003
ରେ ହେଇଛି ବେଲ୍
ବେଲ୍
ମାନେ କେତେ 2 ବର୍ଷ ଅଛି, 2 ବର୍ଷ ରହିଛି।
ନା 6 years
2006
2003
ଆରେଷ୍ଟ କେବେ ହେଲା କି?
31/1/98
ଓହୋ 98
ହେଲେ ଏଟା ହଉଛି 4 years ହଉଛି
6 years 9 months
ହଁ
6 years 9 months
98 ପରା
98 to 2001 ଜାନୁଆରୀ 98 ରେ ଆରେଷ୍ଟ ହେଲା
1900 ତାପରେ 2001 2002 2003 ଆଚ୍ଛା 5 ବର୍ଷ କମ୍ପ୍ଲିଟ ହେଇଯାଇଛି ପୁରା 6 years 5 years କେତେ
so around
5 years 9 months ହଉଛି 8-9 months
6 years 9 months ହଉଛି
କେମିତି 98 ରେ
13 ରୁ 8 ଗଲେ 6 8 6 13
98 ରେ ଆରେଷ୍ଟ ହେଇଛି
ମୁଁ ଗଲି 8 ମାସ
98 ରେ ଆରେଷ୍ଟ ହେଇଛି ଜାନୁଆରୀରେ 98 to 99 1 99 to 2000 2 2000 to 2001 3 2002 4 2003 5 और ये 2003 रे बेल ହେଇଛି
5 years 9
months କେତେ ବର୍ଷ ହେଲାଣି ତାକୁ କେତେ ଅପିଲ ବେଳେ
ବର୍ତ୍ତମାନ 40-42 ବର୍ଷ
ସେଟା appeal ବେଳେ
ନା ସରି
23 ଥିଲା
23
2000 ମସିହାରେ 23 ଥିଲେ ବର୍ତ୍ତମାନ 23 48 years
48
हेड ब्लोज ସେମିତି କିଛି ନାହିଁ ସ୍ପେସିଫିକ କିଏ ଦେଇଛି କଣ କରିଛି
both the accused person
both
ଦିଟା ମ୍ୟାଟେରିଆଲ ଅବଜେକ୍ଟ ଅଛି, ଗୋଟେରେ ବ୍ଲଡ ଷ୍ଟେନ୍ ଅଛି ଆରଟାରେ ନାହିଁ।
नो ଆପଣ କଣ ଗୋଟେ କହୁଥିଲେ କଣ୍ଟ୍ରାଡିକ୍ସନ୍ସ ଅଛି PW
Contradiction if you lordship will see
in what way
if you lordship permits PW2 that you
हाँ PW पढ़ना
Amal Das. I know Sukharanjan PW1. I know accused persons in the dock. I also know Fakir who is dead. The accused person have assaulted Fakir for which he is died. The incident took place about 1 year back at Nuasahi, that is Hadisai Choko. This incident took place when myself, Sukharanjan, Fakir were returning from Tarani Chok Bazaar to our Sahi. We have to go for fishing. Fakir and myself went to the bazaar for purchasing betel, pan, cigarette, etc. Sukharanjan was also there. We cancelled our program to go for fishing as it was chilly weather. So we three returned back from the market. During our return, we are coming with 2 cycles. It was
at the
chalk we saw at the spot Sukharanjan, Biranchi, and Kalia. Kulia,
Kulia.
sir.
Kulia.
ଭଲ ଦେଖା and Basanta, out of joke, started quarreling with each other. So there was
Pela.
Telapela between Sukharanjan, Biranchi, and Basanta on sending them seeing them, the Telapela, the two accused person
And
approached there and asked them
as to why
they were quarreling at the chowk. While telling so why they are quarreling, accused also told Bongali Fongali. So when they told there was quarrel between Sukharanjan and Akshay accused, Akshay told them Sukharanjan and others to go away. While Fakir, Sukharanjan and myself coming away, Akshay dealt a blow by bamboo.
Okay, accused number 2.
Bamboo lathi on his head. The lathi is about 2 cubic. It's in length. So Fakir intervened. Fakir was also assaulted with lathi by both the accused, which is also brought from the centering nearby. At the time of such incident, due to pushing of cycle by Fakir Sukharanjan, I fell down on the ground and both the cycles were lying over me. When I awoke, the accused persons had fled away, but Sukharanjan Fakir was found lying on the ground. So I went to inform the younger brother of Fakir, Robin Malik. Then we took the injured to Anwar Khan Medical, wherefrom they have sent to Kotak Medical. Fakir died in the early morning.
Appellants Abhay Kumar Naik and Abhay Naik face trial in the court of learned second additional session judge Qatar. Speed into in sessions trial number 377 of 1998 for offences punishable under section P41 by 34, P02 by 34 and 307 by 34 IPC. On the accusation that on 28th January 1988,
1998.
98, अच्छा,
98.
80.
98.
98.
This is particular.
1998 at about 11 p.m. at Kopaleswar Hadisahi under Chaudhar police station, they wrongfully restrained Fakir Malik, bracket Legend, hereafter the deceased, and Sukharanjan Mirdha, bracket PW1, and Amol Das, bracket PW2, in furtherance of their common intention, committed murder of the deceased, and also assaulted PW1 with common intention to commit murder. The London Trial Court had judgment and order dated 21/9/2000 to acquitted the appellants of the charge under section 341/34 of the Indian Penal Code, and the appellant Abhay Kumar Naik of the charge under section 307 of the Indian Penal Code, but found both the appellants guilty under section 302/34 of IPC. Stop. The appellant Akshay Naik was found guilty under section 307 of the IPC. Both the appellants were sentenced to undergo imprisonment for life under section 302/34 of IPC, and appellant Akshay Naik was sentenced to undergo RI for 7 years for the offense under section 307 of the IPC, and the sentences passed against the appellant Akshay Naik were directed to run concurrently. The first information report was lodged by PW9 Sailendra Malik, Silent Malik, who stated that on 28/1/1998 at about 11 p.m. He received message from his younger brother Rabin Malik,
PW11,
bracket PW11, that the deceased was coming along with PW1 and 2. Now, while the deceased was coming with PW1 and 2 near Hadisai, both the appellants assaulted assaulted them by means of lathi. Receiving such message, PW9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 , 9 came to the Calcutta Sovereign University Secretary came to the spot and found the deceased as well as PW1 in bleeding condition, and University Secretary Dr. Deki medical portray nature and sent them to the hospital, and thereafter came to Chaudhar police station and lodged the first information report. On the basis of which Chaudhar PS case number 16 dated 28/1/1998 was registered under section 341, 325, 307 by 34 of the Indian Penal Code against both the appellants. Who is the IO of this case?
IO PW12.
Acha.
13.
PW 12 na 13?
13. Akuli Charana Chandra Patra.
Acha, PW 13.
PW 12.
PW 12.
नहीं PW टा देवराज भैया सेटा
AS13 is attached to the medical.
PW 13 then.
13 হবো
PW 13 Akuli Chandra Patra.
Yes.
Akuli Chandra Patra, who was the SI of police attached to Chaudhar police station, on the direction of the officer in charge of the police station, took up investigation of the case. During course of investigation, he examined the witness, the informant, proceeded to the spot, which was Kapaleswara Sweeper Colony Church, and there he examined some witnesses, seized bloodstained earth and sample art from the spot under seizure list, exhibit one by one. He searched the house of the appellants and recovered some photographs of the appellants, which were seized under seizure list exhibit 2 by 1. He received information from the Mangalawak police station about the death of the deceased at while he was undergoing treatment at a civil medical college hospital, Kambalpata, and proceeded to the medical college. So, the IO seized the bloodstained bodies of PW1 at medical college, who was undergoing treatment as per seizure list exhibit 11, and also examined PW1 and issued injury requisition in respect of the injured Secretary PW1. On 31/1/1998, the IO arrested both the appellants. So, while in police custody, both the appellants led the police to poultry farm of Kapaleswar village and gave recovery of 2 lathis, bamboo lathis, which were seized under seizure list exhibit 6. The appellants were also medically examined and then forwarded to court. The IO received the injury report of PW1 from the medical officers. Stop. On 25/4/1998, he sent the exhibits to SFSL Bhubaneswar chemical examination and received the chemical examination report exhibit 12. He also received the post-mortem report and the inquest report from Mangalabag police station. He prepared the spot map and also seized the wearing apparels of the appellants which were stained with blood under seizure list exhibit 14 and 15. On completion of investigation, he submitted charge sheet against the appellants under section 302/341/307/34 of the Indian Penal Code on 28/4/1998. After submission, next para, submission of the charge sheet, the case was committed to the Court of Session where the London Trial Court framed the charges as aforesaid. Since the appellants refuted the charges, pleaded not guilty, the sessions trial procedure was resorted to prove their guilt. In order to prove its case, the prosecution examined 13 witnesses. The prosecution also exhibited how many documents? 100 documents. The defense plea of the appellant is one of denial. The London Trial Court, after considering the evidence of PW8, the doctor who conducted post-mortem examination and also proved the post-mortem report exhibit 7. Came to hold that the deceased met a homicidal death. The London Trial Court relied upon the evidence of PW1 and PW2, the eyewitnesses to the occurrence. And found that the evidence has not been shaken in the cross-examination and it gets corroboration from the medical evidence and therefore it was held that both the appellants are the authors of the crime relating to the death of the deceased on account of assault made by them. The court also held that the evidence of PW 11 lends support to the prosecution case, and the evidence relating to the recovery of the bloodstain lathis, bracketary MO1 and 2, are the instance of the appellants while in police custody was considered by the London trial court, and it was held that the prosecution has proved its case beyond all reasonable doubt against the appellant that they committed the murder of the deceased and also attempted to commit the murder of PW1 by assaulting him. The court, however, held that there was no proof of wrongful confinement of the victim persons by the appellants so as to attract the provision under section 341 of the IPC. Though the London Defense Council raised a submission regarding the exercise of right of private defense by the appellants, to escape from the attack by PW1 and the deceased at the time of occurrence, but such plea was held to be not acceptable. Accordingly, the London trial court passed the impugn judgment holding both the appellants guilty under section 302 by 34 IPC. So also the appellant Akshay Naik under section 307 IPC. Mr. Sabyasachi Misra, you are appointed as amicus curiae.
No.
Legal. The London Council appearing for the this criminal appeal by order dated since the written instruction was received from the inspector in charge of Chaudhar police station dated 12/8/2025 regarding the death of appellant number 2, Akshay Naik, and no legal heirs of the appellant number 2 filed any application seeking leave to continue the appeal, by the order dated 14/8/2025, we passed the order that the criminal appeal stood abated so far as appellant number 2, Akshay Naik, is concerned. Stop. Mr. Sabyasachi Misra and counsel appearing for appellant number 1, Abhay Kumar Naik, submits that from the evidence of PW1 and PW2, it appears that there are a lot of contradictions, and the evidence further indicates that there was no premeditation on the part of the appellant to assault the deceased, who was a peaceful intervener. And when the deceased intervened in the dispute of the prosecution party members and used some language derogatory to the name of the caste, being enraged, it appears that the appellant assaulted the deceased. The Land Council submits that from the evidence of PW2, it appears that it was appellant Akshay Kumar Naik who dealt the fatal blow on the head of the deceased by lathi. And as per the postmortem report, which has been proved by PW8, the other injuries are mostly on the non-vital part of the body. The Land Council submits that since the appellant has been acquitted of the charge under Section 307 IPC, and the fatal blow to the deceased has been attributed against the appellant Akshay Kumar Naik, considering the surrounding circumstances under which the offense is stated to have taken place, it cannot be said that the appellant intended to commit the murder of the deceased, and therefore the case may come within the purview of culpable homicide, not amounting to murder. And since the appellant has remained in judicial custody for about 5 years and 8 months, and he is on bail by virtue of the order of this court since
2003, ना?
21/10/2003
ना? हाँ.
Since by order dated 21/10/2003, and the occurrence has taken place way back in the year 1998, and more than 27 years, no?
27 years.
27 years have passed. The considering the role of the petitioner, even if he is found guilty under the culpable homicide amounting to murder, the sentence be reduced to period already undergone. Stop. Mr. Parthasarathi Naik, learned additional government advocate, on the other hand, submitted that the contradictions which are appearing in the evidence of PW1 and PW2 are minor in nature, and since PW1 is an injured witness, his presence at the spot cannot be doubted, and his evidence is getting corroboration from the medical evidence adduced by PW4, who examined PW1 at SCB Medical College Hospital, so also by the doctor who conducted post-mortem examination, PW. Yes, sir.
The
PM,
PW,
PW 8 PM. No, PW 4 treated
4 PM.
PW 1.
PW 4 টা হচ্ছে
PW 1 को
and
treatment
who was treated?
1.
Ah.
As per which is
PM doctor হচ্ছে PW 8
8. PW 8.
Postmortem doctor, PW.
PW 8. Stop. He submits that the London trial court rightly placed reliance on the evidence of the two eyewitnesses, PW 1 and 2, who had accompanied the deceased at the relevant time, and their evidence has not been shaken in the cross-examination. And since the deceased was assaulted on the vital part of the body, like head and paperwork department, and the doctor has specifically stated that the cause of death was on account of craniocerebral injuries, and it appears that both the appellants had participated in the assault of the deceased, since the death on account of assault has taken place in furtherance of the common intention. The impugned judgment should not be interfered with. Stop. Before adverting to the other contention of the land council for the respective parties, we have to see whether the prosecution has successfully established that the death of the deceased, that the deceased died of homicidal death or not. Apart from the inquest report exhibits one, so the evidence of PW8, Dr. Nirupama Samantrai, Assistant Professor of SCB Medical College, is very relevant on this issue, who conducted post-mortem examination over the dead body of the deceased on 29/1/1998. He noticed the following external injuries, and on dissection he found the following, and she has opined that the injuries sustained by the deceased are antemortem in nature, and the death was due to coma resulting from the craniocerebral injuries, which is fatal in the ordinary course of nature. She further opined that the death was since death was 6 to 12 hours at the time of examination. Not a single question has been put by the Land Defense Counsel in the cross-examination to PW8. The Land Counsel for the appellant has also not disputed about the homicidal death of the deceased. In view of the evidence of the doctor, the post-mortem report findings, we are of the view that the London trial court has rightly come to the conclusion that the deceased has met a homicidal death. Next para. The prosecution has examined PW1 and PW2 are the eyewitnesses to the occurrence. As for the evidence of PW1, there was a program to
catch piece.
make piece.
Catch piece.
to catch fish with PW2 and the deceased.
Come to it.
For which they had come to Bazaar to take some articles, and since it was a chilly weather, they cancelled the program to go for fishing, and they were returning back from the Bazaar and proceeding to their Sahib. PW1 further stated that on the way to their Sahib near Hadisai Chowk, the appellants came and started abusing, for which he intervened, and then there was also exchange of words. He further stated that the appellant over went away from the spot and called his brother Akshay Kumar Nai, and both of them came with bamboo and lathi. PW1 further stated that when both of them were trying to assault, he intervened, and thereafter the Abhay and both the appellants went a little ahead. So he thought that they would not create any trouble. He further stated that while he was standing, appellant Akshay dealt a lathi blow on the back of his head, as a result of which he sustained injury and fell down. Thereafter, both the appellants assaulted him by lathi. He further stated that the lathi blow did not struck him, as he was lying on the ground and it hit the ground. He further stated that both the appellants then assaulted the deceased, and at that time, PW2 fell down on the ground, and the appellants pressed 3 cycles upon him. After assaulting, the appellants fled away from the spot. The deceased was lying in an unconscious state with bleeding injuries on his person, and PW2 went to inform in the house of the deceased, for which some persons came, and both PW1 and the deceased were taken to the private medical at Chaudhwa in a rickshaw, and then they were taken to SCB Medical College Hospital, Cutter, where they were given treatment. But during the treatment, the deceased expired.
On 29/1/98.
29/1/1998. In the cross-examination, PW1, however, stated that এটা বাহারিছি जो confrontation টাইছি, it is not a fact that I have stated before the police that after reaching the swan, so we saw
There was
Sahil
quarrel,
and
right?
quarrel exchange words and ସେଇଠି ଫକୀର କହିଲା ତୁ କିଏ ବି third person এটা প্রুভেছি। আচ্ছা, it has been confronted to PW1 and proved through the IO কিয়ে
13 page 71 paragraph 13
PW13 paragraph number কেতে
12 ଆଉ 13 তিনটা।
PW আচ্ছা
13 টা হচ্ছে
হ্যাঁ, ঠিক আছে।
PW1
that he has stated that after reaching at Sweeper Colony Church, they saw Kalia and Biranchi of their Sahi, and Biranchi and the deceased had exchange of words in the chakra when the appellant Abhay came and intervened. And when
he asked
the deceased was asked as to why he was quarreling, the deceased shouted at him saying, "Tu kiebe third person," and gave him 2 pushes. Hello? In the cross-examination, it has been further elicited that when there was quarrel between the appellant, Abhay, and the deceased, PW1 for 10 to 15 minutes, PW1 was there and he separated them. And the deceased told the appellant, inverted comma ভিতরে, হাড়ি টোকা তু কাহিকি বকবক করছু। So the evidence of PW1 otherwise has not been demolished in the cross-examination, and PW किए ताको examine करथला
4
PW4 who examined PW1 at casualty of SCB Medical College Hospital, has stated that he noticed multiple abrasions on the face and there was a stitch wound in the occipital region of the head, and the patient was discharged from the hospital on next day mane ke beta
on 29
on 29/1/1998,
As there was no head injury.
as there was no head injury. The doctor has proved the injury report marked as Exhibit 3. So also the OPD ticket marked as Exhibit 3/2. The defense has elicited in the cross-examination that the injury in the face were superficial and were possible by fall. We find that the evidence of PW1 that he was assaulted at the spot by the appellant is getting corroboration from the evidence of the doctor PW4. And since he is an injured witness, his presence at the scene of occurrence cannot be doubted. Coming to the evidence of PW2, he has also stated that he, along with PW1 and the deceased, were returning from Tarini Chowk Bazaar to their Sahi, and at the shop they found Biranchi Kulia Basan and
Sukharan.
PW1, Sukharanjan is PW1. They were they quarreled with each other, and
There was push and pull.
There
they-
was tussle
there was
between tussle between Sukharanjan
there was push and pull between them, and
and
the accused persons came there and
Ask them as to why.
when they told
as to why they are quarreling.
Ask them as to why they are.
They approached and let us say asked police challenge them why are they quarreling?
and that he further stated that the appellant Akshay dealt a bamboo blow on the head of the deceased when he intervened, and the accused persons also pushed him, for which he fell down, and both the cycles were lying over him. And then the appellants fled away from the spot. He further stated to have noticed PW1 and the deceased were lying on the ground, and he went to inform the younger brother of the deceased, and they took the injured persons to the hospital where the deceased died. During treatment. आर किसी contradictions prove ହେଇଛି କି ଯୋଉଟା ପଚାରିଛନ୍ତି ଏ ଯୋଉ ଆଇଓର ଦେଖିକି କହିଲେ ପଚରା ହେଇଛି confrontation ହେଇଛି ସେଇ 3rd% ପ୍ରମାଣିତ ନା ଖାଲି it's not a fact କହିଛି ନା ପ୍ରମାଣ ହେଇଛି ନା ନାଇଁ ଦେଖ ଏ PW13 ପୁରା ଆକୁଳି ଆକୁଳିର PW1 ତ ହେଇଛି PW2 ର ତ କାଇଁ ଲାଗୁନି
paragraph 2 ରେ କହିଲା sorry paragraph 12
ହଁ 12 କଣ
PW2 stated before me that when Abhay Naik interfere in that quarrel Fakir Malik stated that
କହିଛି ତ ଠିକ ସେଇ ଜିନିଷଟା ପଚାର it has been confronted to PW এই ଷ୍ଟେଟମେଣ୍ଟଟା କହିଥିଲା ଏଟା ଓମିଟ କରୁଛି ବୋଲି ସେମାନେ ଆଣିଛନ୍ତି ଯେ ତମେ ଏଇଆ କହିଥିଲ ଦେଖ it has been confronted to the appellant and
to appellant.
confronted to a PW2
Petrol
and proved to the IO bracket PW 13 that he has stated before police that when appellant Abhay Naik interfered in that quarrel, the deceased told inverted comma Sala tu kiye be third person and gave 2 blows to Abhay, appellant Abhay. And thereafter, appellant Abhay went away from the spot. It has been further proved that he has not stated before police that appellant Akshay dealt bamboo blow to PW1 and that the deceased intervened at that time and both the appellants assaulted him. Stop. Though there are some contradictions appearing in the evidence of these 2 witnesses, but we find that in material particulars, they corroborate each other. And moreover, their evidence that the appellants participated in the assault of the deceased Fakira is getting corroboration from the evidence of the doctor bracketry PW8.
And my submission, the witness may not depose in arithmetical accuracy.
The Land Council for the state submitted that the contradictions are very natural and it is not necessary that the witnesses should state in a parrot-like version.
Judgment.
Therefore, they are very natural witnesses, and when they were coming together, their presence at the scene of occurrence cannot be doubted. In view of the evidence of PW1 and PW2, coupled with the evidence of the PW8, we are of the view that the deceased died on account of the assault of the 2 appellants, that is appellant Akshay Kumar Naik and appellant Abhay Kumar Naik. Stop. Now coming to the sequence in which the surrounding circumstances under which the offense is stated to have been committed, we find that there was no premeditation on the part of the assault, on the part of the appellants to assault the deceased or even PW1. It appears that while there was a quarrel already going on between some persons, the PW1, PW2 and the deceased were passing by that road, and they intervened in the quarrel and asked them to stop, for which there was a challenge made to the deceased, and it seems that the deceased used some language like which might have precipitated the
third person.
Sequence,
regarding the appellants to retaliate.
The appellants to retaliate. in such a situation, when the words were uttered, it appears from the evidence of PW2 that the appellant Akshay Kumar Naik dealt the blow by means of the lathi on the head of the deceased, which according to the doctor is the fatal blow. Of course, the evidence is there that thereafter both the appellants assaulted the deceased, but as has already been discussed, except the injury on the head, which has been attributed to the appellant Akshay Kumar Naik, the other injuries are mostly on the non-vital part of the body. Therefore, in the factual scenario, we are of the view that the exception to the key penalty.
Reg versus Reg versus
Akshay Naik assaulted PW2. Because while Fakira, Sukhana and myself coming away, Akshay dealt a blow by bamboo lathi on his head.
On
his head.
his মানে কি?
PW2.
কেমন তুমি?
PW2.
Evidence recording is totally fault.
एकदम evidence
মানে প্রত্যেক লাইন তার সঙ্গে কিছু মিলন নেই।
carry sahara carry is technically no correction is there. Sukharanjan is also changing, he is also getting close. Carry sahara.
It aids actually exception one, confirming not only the acknowledgement but the power of the self-control by grain and surprise the death or would get the clarification.
I lost his control.
False if the appellant would come under the exception one, section 300 of the Indian Penal Code. Therefore, we are of the view that the case would not fall within the ambit of section 302 of the Indian Penal Code. Accordingly, the conviction is altered from section 302 to section 304 part 1 of the Indian Penal Code. Stop. It appears that the appellant was in judicial custody for 5 years and more than 5 years and 8 months, and is on bail, which is granted by this court by the order dated कितने order है ना
21/10/2003
21/10/2003, and the occurrence has taken place about
27 years.
27 years. And since the appellant who dealt the fatal blow to the deceased has died, and the appeal so far as the said appellant abates, while convicting the appellant under section 304 part 1 of the Indian Penal Code. We sentence him to the period already. Accordingly, the criminal appeal is allowed in part. But he put a note of appreciation for the insurance.
दस तो पर ही छाड़ दिले
हाँ से नोटिस ये दिया जाए सर्टिफिकेट दिया जाए अब मुझे भी करेक्शन करे तो टोटल टॉस है नहीं माना जस्ट टाइप इट आउट एंड गिवन द विटनेस